In fact, it's a criminal appeal hearing. Almost all the 5 ladies, including Book, it's a non-pending case.
But so many criminal appeals are there and your
My
matter is not there. How can it be?
But since
My lord.
24 it is not being enlisted. So why is not sitting in?
There are so many other criminal appeals which
Ah,
are
so
listed
many are there.
2021, 22,
My lord, may I mention?
23.
My lord, may I mention one matter? My lord, with the leave of Justice
Yes.
Gupta, may I mention one matter before Justice Sinha. This is regarding a personal
Yes.
appearance in respect of a contempt jurisdiction, my lord. There was a direction upon the chairman of the Barapur municipality to remain present at 10:30 before your lordship. My lord, the contemptor is present in court. We are in front of the office of the learned registrar administration. But my lord, the registrar administration is also not available presently. So my lord, that's why my lord, I'm mentioning this matter. The matter is not listed before your lordship.
See, the bench is over here right now. So the principal bench matter, you please record your appearance over there.
My lord, may I request the learned registrar administration to record the appearance, my lord?
Sir, there is a procedure. You have to go before the learned registrar general and get your appearance recorded over there.
My lord, I went there, but just my lord, the registrar general office has sent me here.
You please
That is
take
the-
steps over there. This is not the system.
I know that, my lord. Just to inform your lordship that, my lord, the contemptor is present in court. I am also taking steps as and when, my lord, the
See,
registrars are available.
there cannot be any personal communication between the court and the learned
I
advocate.
agree.
Everything has to be on
agree.
record.
I
So
agree,
you
my lord.
keep records over there.
Very well, your lordship. Very well, your lordship.
Yes.
I'm grateful.
What's it?
Here for the opposite party, we were the writ petitioner for an army personnel who was.
Is it a mandamus appeal? Yes. 2000?
2026 only. That the opposite party has filed this appeal. We are for the opposite party in this matter.
Writ petitioner, that
Yes,
means?
yes, we are the writ petitioner. And the compliance was not done according to the order of the writ petition. Then we filed a contempt and then they prepared this particular appeal,
Alright.
but it has not come into the list.
Alright, give the number.
Alright.
And please intimate your other side.
Yes.
May I get your lordship's indulgence to mention one matter, your
My lord.
lordship? It's a principal
My
bench
lord, in
matter.
item number 1, lordship,
Your
this is
lordship.
an appeal against the order of acquittal. I am the accused person. My lord, I've been instructed to appear on behalf of all the accused persons. My lord, the copy of the paper book, my lord, needs to be served up.
My lord, what happened, your lordship, actually Abhishek Sarkar, advocate on record in this matter, he's in courtroom number 5, your lordship. He's on his legs. He'll come after 2 minutes.
Why is it appearing as to be
Praying for
mentioned?
short password.
Oh, other action. Registration will notify the accused of this matter and the accused is unable to
University authority has no jurisdiction to cause auctions. It is when at the moment the matter comes to the knowledge that it is a foreign origin American art, then and then it is required to be handed over to the customs office.
No, you knew it.
High Court
Yes.
direction.
You knew it. Then why did you not bring this to the notice of the Supreme Court?
Before the Supreme Court. And
That I have to check. My lord, kindly fix it Monday in that.
Why?
After taking information, I will submit.
You are pressing a matter which has been affirmed by the Honorable Supreme Court, right? And your submission is regarding facts which cropped up when the matter was pending before the Supreme Court. What was the reason for not bringing this to the knowledge of the Supreme Court? This is the main thing.
My lord, if I may say something.
Yes, please.
This fact, my lords, if you see the date, what they are relying upon is an ADRF report, which they say obtained from this. If you see their file, my lords, that order dated is, ARDF report is dated 19 June 2025. 20th June. 20th June. And number 160. Kindly see just the timing. This court's order was dated
26th of June.
June. So, my lords, even before passing the order, it was within their knowledge.
No, they got the knowledge sometimes in July.
Yes, on 1st July, it is.
Yes,
it is already
1st of
mentioned-
July. So
it is
immediately
mentioned
thereafter.
In the
And my lords, they did
report
not
also.
need the court's blessing to go refer to customs. Today, my lords, they are a statutory body, they are the state.
No, that's true. But
They don't
just
need this
just
good
tell us something. The court directed the department to sell the goods.
Yes.
Now, if the CGST authority is not authorized to sell it, then what's going to
My
happen?
lords, kindly appreciate.
How
are
can
hinging-
they take
We are
steps?
hinging upon the fact that we had sent some samples to this ARDF where we got the report that this is foreign origin. That is why they want to send it to the customs. Now, lords will appreciate the samples in front of whom these samples were taken, which samples were sent. There has to be a process.
No, that is an
That process
absolute
has already been ended.
fresh cause of action.
But
That
lords,
is
they should have
ended.
brought at the time
No,
when they were
that
passing-
issue cannot be decided at this stage. They
No,
are
no, what
only
I-
asking for modification of the order passed by the division bench.
No, I'm just
Now,
indicating that.
where is
order.
your right to interfere their modification order? When Supreme Court has already affirmed,
Yes.
you have nothing to say in this case.
And another aspect which is very important, Lords, that this ARDF report, what they are relying upon, even I'll show you the Supreme Court order as well, that this is not admissible. On this ARDF report, there is an order from different high courts that. they cannot even
Tell us one thing.
confiscation
Did you
by the
communicate to
customs.
the petitioner that these goods have been found to be of foreign origin? The customs is the authority. We are not the authority. Did you intimate them?
My lord, there was a direction of the honorable division bench to prefer appeal before the appellate authority. I don't know they have,
We
whether
have
they have,
preferred appeal.
they have preferred
Hearing
appeal.
almost complete.
and
What was the result?
Result, order has been reserved.
Appeal for what?
Appeal against the penalty order, because we.
That is
penalty
different.
order.
Yeah.
That is
That
separate.
is something separate.
Different.
Penalty
Nothing
order.
to do with this
But regarding
direction.
auction sale of the
Auction
Americana,
sale.
yes.
No,
regarding-
Lords, auction-
Why don't you intimate the petitioner that these are the reasons that we cannot do it?
No, we have already intimated. It was very much within their knowledge. We have already.
Where is the
intimated.
communication? Show
That-
that you have intimated them that these goods are of foreign origin and the supporting documents. Where are those?
Practically, initially, they have
Not practically initially. Show us that you intimated the petitioners, right? That these goods are of foreign origin and you are not in a position to sell it off. The customs is the authority. Did you intimate in so many words to the writ petitioner?
That I have to check, madam. That I have to check.
Where is the communication that you?
Yes, that I have to check, my lord.
Because and they also have to show that these samples were taken in front of me, Lords, can we appreciate?
Wait.
That
We are
is
not
the
in
process of
that.
investigation.
That is a
Already,
separate thing
already
altogether.
that process has been
You
over.
show us that
Yes,
you
yes, sir.
communicated.
Yes.
The reason for not that you are not in a position to comply the order, where is that? And that should have been there in the modification application.
Yes, my lord. I will submit on this regard Monday. Kindly fix it Monday or Tuesday.
Every day this matter is there in the list.
And Lords,
Every
I'm
day.
suffering, and Lords will appreciate that this auction order was given considering that the goods are perishable in nature. If my lords will see the
Now,
order.
if
But-
that
but
is
they
so,
have
in
preferred
the meantime, it has perished.
SLP
No
before the
use,
Supreme
no
Court.
use
I'm just-
proceeding.
No, it was for my benefit this order was given. my lord.
Now it's
That
gone.
is, I'm just
What is the
asking.
use of continuing with this?
Already, my lords, I'm facing a huge penalty. My appeal has almost, hearing is over. And it will be decided very soon. So, my lords, that will be the fate of this case. They are unnecessarily trying to, my lords, create more hurdles for me just because I brought their commissioner to the Supreme Court and to the High
No,
Court.
No, immediately we have filed this modification petition after getting knowledge.
show us
Regarding
that
the
you
Ericana's,
intimated the
laboratory
petitioner
report.
about this.
Yes.
Uh, Your modification application doesn't contain. It will be.
None, huh?
Application for modification will be preferred by the CGST. Prayer has been made to modify the direction passed by the court in paragraph numbers 11, 12, 13 and 14. In the judgment dated 26th of June 2025. Modifying of paragraph number 7. The submission made by the applicant that the goods in question are of foreign origin and the same cannot be sold by the CGST authority. Where have you mentioned that? Please supporting documents.
Para number 11, my lord.
Supporting documents.
Supporting document regarding report 160, page number 160.
This can.
Can 3. Annexure E. Service করা
Obligation for filing affidavit. Since it here and now. It is not open, there is not. There was a direction for filing affidavit. Did you file?
I have filed. It's already from the last occasion it was filed.
It's taken on the-
Physical service.
This one is 1866. Is 1866.
Now they have this.
And it's by the application to. The CPST authority prays for modification of the paragraph number that the judgment was delivered by the bench consisting of the let the matter be placed before the bench. Honorable Chief Justice for necessary assignment.
Since one of the judges.
Make the prayer. We
So my lord says, releasing.
not
Not
releasing.
releasing, we are only
We
the.
do not have the determination. See, here the bench keeps on changing.
Very well, we file an application before the chief justice, that means release.
You never know. Maybe the next circuit you may get one of the judges. You never know.
Yes.
Just wait and see and then
But we prefer that application. before
keep that application ready. And you can file it over there. In the meantime, your judgment over before the authority can also come.
I do not agree.
Making oral submission, do not file.
NDPS বই আছে তো? NDPS বই আছে।
আচ্ছা আচ্ছা ইংলিশ এখানে আছে একটা কপি
NDPS Act.
How many accused are there? Convicted?
My lord, two. Both are brothers, my lord. Family.
Contraband goods recovered from? Contraband goods recovered.
Contraband was recovered from the house premises, my lord, which was not determined whose house it was, my lord. No document was produced or taken in that regard. My lord,
It was admitted by the accused person.
Why you?
May I start, my lord?
Yes, yes.
My lord, the entire,
Rely upon people.
yes, my lord. My lord, the entire conviction is based upon only the prosecution story, which has no legs to stand. There are no eyewitnesses or independent witnesses to corroborate whatever has been stated by the prosecution, the investigating officers and their team. First of all, my lord, first, my submission is the non-compliance of mandatory safeguards under Section 50 of the NDPS Act. Last day, I stated that the raiding team was the gazetted officer himself was part of the raiding team. In that regard, I will place the cross-examination. Cross-examination. My lord, page 16 of the paper book. One six. Mr. Raju Mukhopadhyay, Intelligence Officer of NCB, Kolkata. My lord, the third, fourth paragraph, my lord. I have stated him about the principle of Section 50 notice and stated him about his legal rights. I also stated him about the GO with us who happens to be BSF Assistant Commandant in terms of Section 42 of the NDPS Act. So their officer has accepted that the gazetted officer was with them. The procedure is as per Section 50 that after reaching the spot, if they apprehend that yes, there may be some contraband article, they will inform the superior officer to engage some gazetted officer or the executive magistrate. But here, the gazetted officer himself was part of this raiding team. So So there was violation of, my lord, section 50. No, my lord, memo copy. Last week. কোথায়? পেয়েছো? No, my lord, in this regard, Honorable Supreme Court in State of Rajasthan versus Permanent
Please
reiterated
tell
that
us whether Prashanta Mandal was present at the spot when the raiding team reached.
as per the prosecution's story, they were
He
present.
was present.
Yes, my lord. But there was no witness to corroborate their fact. The witnesses list which they have provided before the trial court or in the charge sheet, in the during the trial, they have stated that one person was in the market in the evening. He was called from the market and taken signature. Another person signature was taken in a blank paper. So these were all stated in the. I'm coming to that, my lord.
The page 16 itself says that Prashanta was there.
But this is the
Prosecution.
Yes.
investigating officer, my lord.
Right.
Yes, my lord. He says.
He says that the Prashanta was there.
He says the Prasanto was there. And he says that there were independent witnesses also along with the team.
Yes.
But those independent witnesses categorically stated that they were never part of the team. They were called in different hours, taken signature, and they don't know anything about this case. Now, my lord, next page, my lord, page 17. The exhibit which was given, paragraph 2. This is the copy of section 50 notice issued to Prashanta Mandal. It bears my signature. The accused also endorsed in the said notice with signature in presence of IW's independent witness, my lord. So this is the fact that in presence of the independent witness, and then independent witness himself states that I was never there. I was in the marketplace in the evening. I was called and taken my signature.
Arjun Mandal was also present at the residence.
Yeah, both were.
Both
As
were
per the
present.
prosecution,
As per the
both were there.
prosecution case.
Yes, my lord, both were there. As for the prosecution story. But the thing is that signature of independent witness, how it appears when they themselves say that we were not there. So this testifies the entire the vitiate the entire prosecution story. Now, my lord, same. Now, my lord, if my lord takes up PW3, page 20. Prosecution witness number 3, Ajit Biswas. His name appears in the seizure list and memo of arrest everywhere. My lord, may I read? I have come to depose in this case today after receiving summons from this court. I am unable to recall any incident in connection with this case. I do not know anything in this case. I was not interrogated by the IO of this case. At this stage, witness declared hostile by the prosecution and he is permitted to cross-examination by the prosecution. Now, my lord, in the cross-examination, witness is shown exhibit 9, which is the seizure list, my lord. Seizure list, search and seizure list is at page 6 of the paper book. It's part 1 or part 2? Page 6, my lord, for once. Page 6. Search come seizure list. My lord, kindly, this document was shown to him and he denies his signature. At the bottom, my lord, Ajit Biswas son of Kutiswar Biswas.
He also denied his own signature.
Yes, he has not put any signature. Now, my lord,
No,
Furthermore.
Vishwas's signature is appearing in the seizure list,
yes,
although he denied his signature.
yes, my lord. He
That
further
was not
states,
subsequently
no, my lord,
examined by the trial.
no, my lord. Now, my lord, again back to page 20, my lord, that this is not my signature here, exhibit 9-1, exhibit 10, not my signature. Now, not a fact that I was examined by the IO of this case, or that I stated to the IO of this case that on 22nd January 2022, at about 6 a.m. in the morning, team of NCB and BSF went to the house of Prasanto Mondal and recovered 24 numbers of sacks of Gaja from the said house. Or that I stated to the IO that they also went to the house of Arjun Mondal and recovered 21 numbers of sacks of Gaja, which was weighed in our presence, which was found to be in total 690 kgs of ganja. Or that I stated to the IO that all those sacks were, he denied all these facts. Now, my lord, further cross-examination on the bottom. When I put this signature on this page, it was completely blank. Trial court did not took this into consideration.
Page 6 was blank.
Yes, my lord, when the signature was taken, it was blank.
6.
My lord,
The cross-examination that he is
as per the procedure, my lord, these witnesses, whenever a raid conducts, witnesses are taken from locally. Now, if a person is taken locally, how a type copy bears his name and senior name? Kindly see in the page 6, the names are already typed. Witnesses' names are already typed. It is not possible that they took the type copy from there.
Whether IO stated in his evidence that the signature was obtained in the signature list at the spot.
Yes, my lord.
It was
Now,
stated.
again, we'll come to the IO, my lord. The page 16. Oh, yeah, IO is page 24 to 34, my lord, page.
16
16 is his seizure officer, my lord, who conducted the raid. Yes, my lord. Kindly take up page 19. Page 19 for once.
90.
19.
But
Further
before-
cross-examination of PW2.
First part.
My lord,
The first part of page 19. This is further cross-examination.
my lord, 18, page 18. Page 18, my lord.
This is different.
Page 18, bottom, my lord.
16.
Yes.
The IO of this case did not seize the train ticket by which I came to Kuch Bihar from Kolkata. I received the source information in this case. I noted it down in the NCB 1 form. I do not know whether NCB 1 was seized from me by the IO of this case. The movement order was not seized from me by the IO. I, along with Sipai such and such, such and such and such and such, came by train from Kolkata to Falakata. From Falakata, we went together to the camp office of 17 BN Battalion, SSB Falakata. On the next day, that is on 21st of January 2021, we together went to the office of the BSF 47 Battalion, Gopalpur. From Gopalpur, I, along with such and such with the BSF team, including Lady Constable, went to the PO. I did not make any requisition for the presence of Panchayat Pradhan at the PO on the relevant day and time. I did not take any steps to ascertain the ownership of the said house. Like I said, that ownership was not ascertained by the team. When we entered the said house, we found 2 children, 2 women, and 2 male persons present inside the house. I did not obtain the signature of 2 women at the time of search and seizure. I did not make any arrest from the said house. I stayed in the said house for about 2 hours 40 minutes. The signature of Ajit Biswas was obtained in my presence. How? If we go back to page 60, the seizure list. So that is never possible, my lord. How they knew that Ajit Biswas, they will find Ajit Biswas on the spot, and that's why they took the type copy along with them. Other things can be typed, but these particular things about the witness, his residence, father's name, that can only be taken on the spot, which are handwritten, not typed. I returned alone. Next, my lord. I returned alone straight away from the house to the office of the BSF 47 Battalion, Gopalpur, at around
So he
12:30.
has not said regarding other seizure witness.
No, my lord. He stated about only one.
Noren. He did not state
Noren
anything.
Sarkar, my lord.
The another witness. He was also present there as per prosecution case.
No, he did not stated about
Say
Noren
anything
Mondor, my lord.
about the
He
Noren.
only stated about this Ajit Biswas.
Because Noren has in cross-examination admitted that he put all the signature in the BSF check.
Yes, my lord.
In page number 20.
I'm coming to that, my lord. There are many contradictions. Continuing with page 19, my lord. I received the said information on the relevant date at around 8:15 p.m. After which I informed about the matter to my such and such, and thereafter his office gave the information to 17 Battalion SSB Falakata. Not a fact that the date given in Exhibit 9 and Exhibit 9(1) was written by me subsequently after the said date in the interest of my case. The timing of the order is not given in the movement order. I do not find any endorsement of receiving by SSB in Exhibit 7. The timing of issuance of this letter is not mentioned therein. So he has admitted everything, my lord. Now, my lord, PW4, my lord. Noren Sarkar at page 22.
With the another
Another
seizure witness.
witness. I have come to depose in this case today after receiving summons from this court on 21st of January 2022 when I was in the market at around 7:30 p.m. I was forcibly taken by BSF personnels. I was, my lord, kindly note the timing, 7:30 p.m. I was forcibly taken by BSF personnel to Gopalpur camp, and they kept me there that night. That night, he was in the BSF camp. I was made to stay overnight there. In the night of January 2022, I was forcibly, the next day, I was forcibly made to sign on a paper by BSF personnel. On the next day, that is on 23rd January 2022 at around 9:30 a.m., I was asked to go. So since 7:30 p.m. on 21st January till 9:30 a.m. 23rd January, he was detained illegally by the BSF officers just to make their case. And since his name was also typed in the seizure list, that is not possible. I was not interrogated by the IO in connection with this case. This is my signature here. The signature of the witness on the said exhibit be marked as such and such. So he has accepted that signature is his in the seizure list. But when he has signed, he has already stated that. Not a fact that these signatures were made by me in the house of Prashant Mandal. He states that also.
Aman Kumar Sadban is I. He is the IO 8, 40 present. Serial object forever.
Now, my lord, next is at page 24, the IO, Amol Kumar Sadhukan.
Apart from these two, seizure witnesses, no other witnesses
No, my lord,
were
there is
present
no
or
instance of
signed
the.
the seizure.
And moreover, the gazetted officer himself has contradicted the entire story of the prosecution. He has contradicted everything.
So seizure witness did not support the prosecution.
No, my lord. And until and unless the
seizure
seizure
also.
witness supports the entire recovery features, because on the last date, if my lord recalls, Mr. Tridip Saha has categorically stated that there was a huge quantity which were recovered, and there were, my lord had asked whether there were any antecedent or any connection, previous connection. He said yes. But in the entire conviction, there is no such reference regarding any antecedent, prior antecedent, or any information or any transaction that these contrabands were stored for transporting or to impart with some other drug dealer. Nothing. There is no instance, no CDR, nothing. Not a single document to establish that. My lord, you will.
I think if we focus on the judgment, we find out if the judgment has considered something that was not to be considered by the trial. My lord, the matter will be cut short and easier for everyone.
It will not be easy for him.
No, my lord, whether
We
these two
want
will,
to show the discrepancies.
but first he has to show the court the judgment that he is challenging.
We'll go to that.
Judgment is based on.
Yes.
Now, my lord, page 24, the investigating officer, what he stated. My lord, I'm starting from that the bottom fifth line from bottom. I reached at the seizing spot at around 9 hours on 22nd January 2022. On reaching the spot, that is the residence of Prasanto Mandal and Arjun Mandal, I noticed seizing officer and BSF team, two independent witnesses, namely Noren Sarkar and Ajit Biswas, to be present there. Prasanto Mandal and Arjun Mandal were also present inside the house. Thereafter, I took over 690 kgs of ganja contained in the 449 gunny bags, seizure list, notice under section 50, and one envelope marked as D. So the seizure list from the spot here, IO collected, and he states that those two witnesses were also present in the house of the Prasanto Mandal, although that was not ascertained whose house it was. Now, my lord, again going down, my lord, in the middle portion, my lord, next page. Thereafter, I conducted search over the persons of the accused persons and recovered from therein some personal documents of the accused persons, which were one Samsung Galaxy phone, notice under section 67C, notice under section 50, arrest memo from the personal search of Prasanto Mandal, and notice under section 67C, and such from Arjun Mandal. Now, my lord, page 26. From the
So their
top.
personal was also searched.
Yes, my lord. Their personal were also searched, but nothing could be recovered, only except those notices and mobile
Personal
phones. document
and one Samsung Galaxy was arrested.
On 25th of January 2022, I complied with the requirements of 52A NDPS Act in presence of learned James Second Court, Kuchbihar, and got the inventory checked in. During such proceedings, 98 samples were drawn by the learned magistrate and were marked as sample 1 to sample 98. Well, there was a delay in sending the sample, 3 days delay in sending the sample and inventory, 3 day delay in inventory, and the samples were sent on 31st, after 6 days, 9 days. What?
9 days, seizure 9 days.
From the seizure date is 9 days, and from the date of inventory is 6 days.
No, 52A was complied on 25th. Before
25th.
the magistrate.
Yes,
That
madam.
is 3 days deal.
3 days, after 3 days. 3 days. No, that I'm not going to, but the sample was not sent immediately. After a rule 13 and 14, my lord
It
knows.
was sealed.
My lord. Rule 13 and 14, my lord knows. Now, thereafter, I gave written notice to, thereafter I given written notice to the Naren Sarkar and Ajit Biswas, who were the independent witnesses of this case under section 67 NDPS Act. Both these persons did not comply with the said notices, due to which I went to their respective houses and managed to record the statement of Ajit Biswas, which was written by myself on his instruction, as he had an operation in his eyes on the relevant time. So, and if, my lord, a person who has eye operation and he cannot see, he was part of the team to witness the recovery of contraband. I could not obtain the statement of Naren Sarkar as he was not found in his house. Thereafter, I filed final complaint in this case before the landed court. Now, my lord,
That is also true. That is cross.
as per the cross-examination, my lord, this IO was never present at the spot during the entire search and seizure process. Now, my lord, at page 30, second last paragraph, my lord, I did not prepare any rough hand sketch map of the PO during investigation of this case. Excepting NCB team and the BSF team, two independent witnesses, namely Naren Sarkar, Ajit Biswas, and both accused persons and their family members were present at the PO. I stayed at the PO for about half an hour on that day. I returned with the accused persons, this seized articles separately, while my team members left the PO separately. I am unable to say as to how long after my reaching the BSF camp Raju Babu arrived there, but I can say that he arrived after my arrival. I did not seize the train ticket of Raju Babu by which he came to Kuch Bihar from Kolkata. It is true that the notices served upon the accused persons under section 67 NDPS Act does not contain the signature of independent witness. So the notices which were served, which is very vital in NDPS cases, 67, they did not contain the signature of the independent witnesses. Also, these notices did not contain the signatures of the family members of the accused persons. Now, my lord, page 30, page 35, my lord, the vital.
He denies that the signatures were not taken at the BSF camp. This he denies.
He has denied that, but he also confessed that the signature were not there in that 67 notice. Now, my lord, the most vital is the gazetted of Mr. Birender Kumar, the gazetted officer in this case. Page 35. Prosecution witness number 6. I'm not reading from the
He
top,
was
my
in
lord.
the rating team.
Yes, he was
He
part
was
of
in
this
the- part
rating
of the
team.
rating team.
Presently, I am posted at Assistant Commandant 47 Battalion BSF at Chhattisgarh. On 21st of January 2022, I was posted at POP Fulbari PS Sitalkuchi as company commander. On that day, I was informed by my headquarters that in a house in village Makpala 2, PS Sitalkuchi's huge quantity of ganja was stored. I was also told that NCB team from Kolkata would arrive at our headquarters at Gopalpur and that I would have to assist them with my team for their raid. On 22nd of January 2022 at around 4 a.m., I left my BOP Fulbari along with my BSF team and proceeded to the said house in Mekpala 2. And on our way, we met the NCB team who then joined us and we reached the outskirts of the said village together at around 5:30 a.m. Now, my lord, the next line, my lord. I then approached two villagers to find out the house of Arjun Mondal in the said village, and they led us and showed the house to me from a distance. We then cordoned off the house and then knocked at the door of the house of Arjun Mondal. I asked the person who answered the door his name, to which he replied that his name was Arjun Mondal.
Someone has told at the time of knocking the door, someone, Prashant Mandal came out. Here Arjun Mandal came out. Someone told, no, earlier?
Yes, my lord.
Prashant Mandal was there.
That the IO,
Page number 16.
seizure officer, my lord. That is the seizure officer.
One person can open the door and disclose his name.
In this
Contradiction.
my lord, deposition, you will not find any instance of any independent witness. Whether during this, the first paragraph only, he stated that I approached two villagers to find out the house of Arjun Mondal. They showed us from far distance, that is the house, and they went away. While this conversation was going on, Arjun Mondal, and then I introduced myself as well as the NCB team to the said person and disclosed to him that we had information that he had stored ganja in his house. While this conversation was going on, two ladies and some children also came at the door from inside the house. Arjun then told me that there was nothing of that sort in his, and that we could come in and search the house, at which our team and NCB team jointly went inside the house. So the NCB team and BSF team, they jointly entered the house. But the seizing officer, he said that the door was opened by Prasanto Mondal. And there were two persons inside, two male person, children, two women. That was the narration of the seizing officer. But the gazetted officer narration is completely different from what stated. Now, team jointly went inside the house. We also found that one other male person inside the house who was the brother of Arjun Mondal, namely Prasanto Mondal. On search of the house, we found some sacks in one of the rooms of the house. We then brought out all those sacks from inside the room to the courtyard of the house. The NCB team found some similar sacks outside the other rooms, and these sacks were also brought to the courtyard. Thereafter, our team with NCB team opened all the sacks to check them and found that they contained ganja in them. Thereafter, the sacks were weighed by a weighing machine brought by the NCB team. The 49 sacks so weighed were found to contain altogether 690 kgs of ganja. Thereafter, NCB official took out some samples from each of those sacks in my presence and put them in separate envelopes and packed those envelopes. The NCB team then repacked the open sacks. Thereafter, NCB officers prepared a seizure memo over their laptop and printer, which they had brought to the house, after which two people signed over it. So they brought laptop printer, they printed it on the spot, and two people signed over it. And who were those two people? When on the first instance, there was no witness. Again, from where? And he had not described that two people were the independent witness or anything. Two people signed over it. And thereafter, I signed over the said seizure memo. Thereafter, I left the house with my BSF team and went back to my PO. Now, my lord, in cross-examination, page 37. For middle, I am reading, my lord. The NCB team comprised of about 3-4 people. All the members of the NCB team whom we had met on our way at
As
the
per the prosecution case, the laptop was brought to the spot. And
as per his
laptop
statement,
and
the
printer.
laptop and printer.
The standard procedure, wayment machine, laptop and printer.
Everything
are
you.
always carried on the spot. At least Mr. Santanu's one grievance has been answered. The house would be taken.
Please note it down, we will take answer from you.
The NCB team comprised of about 3-4 people. All the members of the NCB team whom we had met on our way at the set point had proceeded with us to the said village. We took about 5 minutes from thereafter to reach the said house. The search process took around 1 hour and thereafter seizure was started. Excepting the 2 persons who had signed on the seizure memo, other than myself, there was nobody else who signed on the seizure memo in my presence. I do not know which 2 persons had so signed. I did not convey in writing to Arjun Mandal or Prasanto Mandal that they could search our vehicle kept outside. So the another notice which is mandatory was not issued by the gazetted officer to search the police personnel or the BSF personnel or the NCB team or their vehicle. No notice was served. At the time of operation inside the house, no outsider came there. No outsider came there. Then how the witnesses will enter? We did not issue any notice to any panchayat member or pradhan of the area. We did not peruse any document of ownership of the house when we were inside. The sample packets of ganja have not been shown me today in the court at the time of my deposition. I will not be able to say which particular NCB personnel had prepared this seizure memo. My lord, next, my lord, page 38. Here, my lord, he states that he has the said village are together at around 5:30 a.m. Or that I then approached 2 villagers to find out the house of Arjun Mandal in the said village, and they led us and showed the house to me from a distance. Or that we then cordoned to the house and then knocked at the door. Not a fact. Acha, not a fact.
একটা সিপাই যে এখানে রেটিং টিম ছিল PW7 যে বলতে 21 যে ওরা রেট কন্ডাক্ট করছে 22 PW7.
Well, next is 39. Asim Kumar Mondal, he was part of the raiding team. I am a Sepoy constable of NCB now attached to NCB Kolkata General Team. On 19th of January 2022, I was posted at the same place in the same capacity. On 19th January 2022, in the morning, I was directed to accompany Sri Raju Mukhopadhyay, IO Intelligent Officer, NCB, such and such to accordingly, I and Sepoy Rehan Raja accompanied Raju Babu in the evening on the same day, carrying with me preventive kit from Kolkata. We reached Falakata by train on the next day in the morning on 22nd January 22 and straightway went to SSB camp in Falakata. Later on the same day, we went to BSF camp at Gopalpur. On the next day, that is on 21st, at around 4 a.m. The search and seizure took place on 22nd, but he has a different. He already did it a day before, on 21st. Everywhere, my lord will see that the search and seizure was on 22nd of January. But he stated that they reached the spot on 21st of January 2022 at around 4 a.m. We left the BSF camp along with BSF force and went to Mekpal, 2 village at around 5:30 a.m. Maybe it is
7:30 ইন্টার সিজন হচ্ছে সকালবেলা 7:30 তে ইন্টারভিউ মাসে ইন্টার প্রসেসিং করে সকালে
Now, my lord, I am coming with my learned senior friend, Mr. Majidov
They
stated that.
reached the spot on 21st
Yes,
in
ma'am.
the morning,
They reached the spot on 21st morning,
5 a.m.,
5:30.
5:30 a.m.
Yes, my lord.
And they reach at home 5:15 a.m. Seizure list was prepared on
22nd.
22nd,
Actually, the case
6:15
was
hours.
on 21st evening, everything was done. The witnesses states that.
And completed at 18:15 hours on 22nd.
Yes, seizure list, my lord.
We left the BSF train and reached the village around 5:30 a.m. But his condition is different. But we cannot. A ticket was produced when they were came from Calcutta.
No, no tickets were produced, not taken, or not asked for. As it is evident
one
from.
Officers came from Calcutta.
Yes, my lord.
So the ticket has been produced before the trial court.
IO stated himself, the seizure, that nobody collected it and we did not give us.
Okay, proceed.
My lord. Now, my lord.
We have to see other
Defense. 86. My lord, the trial court has, the judgment itself will state that trial court has not considered the serious nature of this offense or the seriousness what was required under the statute to have been followed while delivering this judgment. Now, I'm directly coming to page 86, from where the defense has submitted their case before the learned trial court.
86.
Yes, my lord. The second part. Page 86, my lord. Bus. The learned,
Here section 50 is applicable.
yes, my lord.
How?
Mandatory
When
for
the seizure was made in enclosed place. Whether section 50 is applicable. Number one.
yes,
Another-
any place it may be.
No.
But section 50
If
guided
only person to be searched, then only section 50 will apply. And even if nothing found from the pocket or inside their body, then section 50 will not apply. Here, actually 42 will apply.
My lord,
Because-
42, I'm coming to all those provisions, my lord. 50, in section 50, whether it is personal search, bodily search, or a premise search, or outside premise search, gazetted officer cannot be part of the raiding team because it visits the entire proceeding of issuing of notice.
The
Kindly
difference
see,
between-
if
difference
for
between-
argument's sake also we consider, then why this section 50 notice was issued? The gazetted officer himself
That
said,
notice was issued to search the person. And
search the
if
person.
person was searched, nothing was found. What is the use of that section 50?
My lord, then what is the,
Number one. Number two,
My lord.
when anything recovered from vehicle, suitcase, or storeroom or house, that is the enclosed place. And if it is search and seizure made in enclosed place, then section 42 will apply.
my lord, section
And
42?
section 43 will apply where the vehicle is in public place or search and seizure made in
My lord,
public
my
place,
lord, absolutely.
then 43.
My lord.
Now tell us here, while considering the 42 section, whether that was complied or not. If you go by the section 42, that is also a mandatory provision that should be complied by the officer who sees the vehicle, who sees the ganja. And it is admitted fact that nothing was recovered from the possession,
Yes,
the
my lord.
personal possession of both the accused persons. So here section 50, I think, does not apply.
My lord, why
Please
section 50?
clarify.
I am stating about, my lord.
How section 50 will apply? Please tell us.
No, my lord, if for once my lord takes up any case act,
Yes.
section 50, my lord. Conditions under which search of persons shall be conducted. When any officer duly authorized under section 42 is about to search any person under the provisions of section 41, 42, or 43, he shall, if such person so requires, take such person without unnecessary delay to the nearest gazetted officer of any of the departments mentioned in section 42 or to the nearest magistrate. If such requisition is made, the officer may detain the person until he can bring him before the gazetted officer or the magistrate referred to in subsection 1. The gazetted officer or the magistrate before whom any such person is brought shall, if he sees no reasonable ground for such, forthwith discharge the person, but otherwise shall direct the search be made. No female shall be searched by any one excepting a female. When an officer duly authorized under section 42 has reason to believe that it is not possible to take the person to be searched to the nearest gazetted officer or magistrate without the possibility of the person to be searched parting with possession of any narcotic drug or psychotic substance or controlled substance or article or document, he may, instead of taking such person to the nearest gazetted officer or magistrate, proceed to search the person as provided under section 100 of the Code of Criminal Procedure, 1973. After a search is conducted under subsection 5, the officer shall record the reasons for such belief which necessitated such search, and within a 72 hours send a copy thereof to his immediate official superiors. Our section
So
50.
in case person search,
My lord, here
condition under which search of a person shall be conducted.
shall be conducted.
So anything was recovered from their person.
My lord, if my lord says that section 50 particularly says about the search of person, But here it is stated that he has to take into account section 41, 42, and 43.
Hmm.
And as whatever the case may be, it has to be done by a gazetted officer or the executive magistrate. The
You
information
see,
has to be given.
When any officer duly authorized under section 42 is about to search any person
Yes, my lord.
under the provision of 41, 42 or 43.
All are included.
If
41, 42,
suppose
43.
someone is in vehicle, search and seizure conducted by the investigating team or raiding team. If raiding team want to search the driver body, then only 50 will appear. And if the vehicle will search, then which section will be applied?
My lord, even
43.
43 has been taken into account. All these.
Similarly, if a person go to search and seizure a house, the officer may search the personal body or person
My lord,
himself,
my lord.
and the accused and the store place. Then which section will apply?
42, my lord.
42. That's why 42, 43 was given here. But the purpose of section 50 is only when question arises to search a person. Then a legal right to be informed by the officer that you are to be searched in place of gazetted officer, either or magistrate. Then the option of search would be from the side of accused.
Now, my lord, in this case, the gazetted officer was part of the raiding. Now they have entered, they found some sacks, they kept it. Bodily search was also made.
Yes.
So
But
that does
nothing
not
was-
vitiate the proceeding.
No. That
Because
will
the
not-
gazetted officer was
If
already free.
something recovered from the body, then the question of section 50 will apply.
My
Whether
lord-
that was properly maintained or not.
When the gazetted officer was part of the team, who will testify? Who will testify?
Okay, according to you, it is
My lord,
maintained
if my lord,
and it is mandatory.
my lord knows that in state of Rajasthan versus Permanent, it has been,
Permanent Baldev Singh is there.
Baldev Singh
There
is
are
also there,
others.
my lord, very
Judgments
there,
are-
my lord.
several
Then,
judgments on this issue.
Ramchandra is there.
Vijay Singh,
You
Chanduba,
refer those, but
I will
just
refer to
now
those,
I
my lord.
clarify about the which section will apply here,
My lord, here, my lord, 50 is applicable, my lord.
according
because-
to you.
Yes, my lord.
And 42 is
42
also
is
applicable.
applicable.
42,
Because both were done.
42 and 50 both are mandatory provisions that must be complied
Yes.
with by the investigating officer
Officer.
or the raiding.
Yes, my lord. Now, my lord, we go to the judgment. Judgment,
Anything, if you want to show the other deposition of the
no,
raiding team,
depositions, those which were main deposition on the basis
you have
of those
already,
whom the entire case.
now you show us.
I'm reading the judgment where, my lord, my learned senior friend has stated that I'm not going through the judgment. Whether he needs,
You place it in your way.
Your way, yes.
my lord, I'm placing.
Yes.
Page 86,
Ultimately, we have to assess everything
my lord.
because we are hearing the appeal. So we have to tell you the evidence, deposition as well as judgment. Otherwise, how we can come to conclusion that assessment or appreciation by the trial court was proper or not?
Yes, my lord. My lord, page 86. The learned advocate of the accused persons, on the other hand, categorically submitted that the prosecution failed to bring home the charge against the accused person by producing convincing and reliable evidence. It is submitted that the facts relating to recovery of Gaja from the prosecution of the accused persons has not been convincingly proved beyond all shadow of reasonable doubt, and that it is not proved that either or both the accused persons were the owner of the LSPO house. He also argued that the gazetted officer was a member of the raiding team and thus the search was vitiated due to non-compliance of the statutory requirement of Section 50 of the NDPS Act. This point was taken before the trial court. He also argued that none of the two independent witnesses supported the prosecution case any bit and that both of them turned hostile, due to which prosecution case of recovery and seizure of Gaja from the LSPO house in presence of these independent witnesses becomes suspect. Learned Defense Counsel also argued that PW7 had stated in his evidence in chief that the NCB team had come to Kuch Bihar on 20th of January 2022 and went to SSB camp at Falakata on the same day they also went to the BSF camp at Gopalpur, and on the next day, that is on 21st of February 21st of January, my lord. 21st of January 2022, the NCB team along with the BSF team went to Makpala, to village at around 5:30 AM. While the prosecution's case was that NCB and BSF team had gone to the same village early morning on 22nd. What the dates?
Again, typographical error.
No, which
Typographical error,
contradict?
22nd of January 2022. Which contradiction makes the search seizure which happened at PO house on 22nd of January 2022 to be doubtful. The foremost contradiction is, my lord, the date.
January, all are January.
January, it
not-
will be
not
January,
February,
my-
but date is different.
Date is different, my lord.
Date is
Because as per the story, it was on 22nd
This is the typography.
January 2022. But the witness and the
Both should be January.
witnesses states that it was 21st of January 2022, which has to be taken into account. Now
So
the
these are
finding,
the points from your side,
yes, my lord, more are there, my
even
lord.
today.
Now,
Any more point you are raising?
my lord, Kedingwell, independent witnesses were missing, my lord. That creates a serious doubts. Then, my lord, no connecting circumstances linking the accused with the Alice contraband, which I stated in the earlier, that no CDR or no link, that these were the articles were for the purpose of transportation or selling or anything. No linkage was drawn up. No CDR was taken that they were drug peddler or anything in that regard. Next, my lord, is CDRs. Now, my lord, failure to establish conscious possession due to lack of corroborative evidence and incomplete chain of circumstances, which is very important because in NDPS Act, what matters is the possession and it should be conscious possession. Now, as I stated earlier, that since there were no CDRs, mobile towers, CCTV footage, nothing, even the videography was also not done. Absence of videography.
Mobile was seized, that was not sent for FSS.
No. In the entire seizure process, no videography was done and no electronic footage of the entire search and seizure was never there. No. And any statement regarding admission before the police officers or the raiding team is not admissible in law. My lord knows that. So, previously, Mr. Senior Counsel said that they have admitted the accused person.
Confession and.
Yes, ma'am. That will not, is not admissible. My lord, that's all, my lord. I'm just, my concluding argument is, my lord, they are innocent. They were implicated in this matter. There are no such independent witness or any prosecution could not present a single witness or single document or single videography to prove that the search and seizure or the entire recovery was made inside that house premises from these two persons, my lord. That's all, my lord. I'm submitting my written notes of argument.
And any judgments that you would like to.
But I have already stated in my written notes of argument, my lord. I will provide
But
those.
then if you do not place it, how will your learned senior friend controvert it? It has to be.
I have given
Have
you
you already given the?
copy of this one. I have given one. What I am relying upon, I have given a copy of that.
Judgment here.
My lord. I have mentioned the citations in my arguments. My lord, I have cited all the judgment in my written notes of argument.
Yes.
The hard copies of those judgment I will provide tomorrow, my lord, at the time when, my lord, Mr.
On
Mahanta
what
will.
issue you have referred those judgments? Tufan Singh,
Tufan Singh is there, my lord,
Tufan Singh
permanent
you
is there.
have Noor Agra is.
My lord knows all those judgments very well. Noor Aga is there, my lord. Avtar Singh is there. Bal Mukund, there, my lord. Dharampal Singh. Mohanlal, my lord.
Okay.
I will provide all the hard copies of those judgment tomorrow, my lord.
Yes. So mainly, he has argued 5 points. Number 1, no convincing evidence brought on record to establish
Chain of
the charge.
evidence was missing.
No ownership of the PO
Could be established.
established. Section 50 not applied, not compliant. And so far as section 40 is also important. He has not argued.
No, I have, in my
You have-
written notes of argument.
42
by-
is also important.
Yes, my lord.
And 2 independent witnesses have not supported the
Independent
prosecution
witnesses have
case.
not supported the prosecution.
And there is a discrepancy with regard to the date of
No, only one
search,
single-
seizure, and
In only one single instance.
so these 5 points he has raised. So you have to confine only
I
on
have
those.
already requested your lordship.
CDR, videography, nothing of this.
My lord, at that relevant point of time, it was not mandatory. Because of 2021 was.
And even for searching in the enclosed place, videography is necessary.
At that point of time, it was not necessary.
Now it is
Now,
necessary.
any season, any sort of.
Any
season has
seizure,
to be videographed.
videography.
No, my lord, my learned friend has raised first, and the main thrust of his armament was to the confusion in whether the place at all could be ascertained to be a Prashanta Mondal and only. Now, my lord, if we believe these statements, then the address given by the appellants in the memo of appeal, which appears in page 107 of the memo of appeal, is false.
It is the same place which has
My
been
lord,
searched.
kindly takes page 6 of the paper book and confirms it with page 107, the two addresses given. Nowhere the defense brought out any case that this address is not the address that should be. My lord, kindly sees page 6. The Caesar memo.
Village 2 number Macpala.
Lordship. Now, my lord did not go to page 107. I am reading it out for you, Lord. Prashanto Mondal, Arjun Mondal, village and post office 2 number Macpala, police station Sitol, district Kudibihar. So now if the appellant comes before this honorable court and says the address that is given would not be ascertained, then his address that is given in that memo of appeal is false. My lord, it is very easy to say something and get away with it. But he,
I would like to,
Wait.
my lord, I would like to reply to this.
Yes,
Certainly
you
you'll
will.
get a chance. Take note and
my
reply.
lord, the Caesar memo address given in the Caesar memo at the place of Caesar, and the appellant gives his own address in the memo of appeal. My prosecution Caesar memo may be wrong, bogus, baseless, but he is aware of where he resides. Both the address matches. Apart from the gazetted officer's evidence and other evidences on record, my lord, which goes to show that local people were asked, whose house is this? Where is this man living? And they showed the house. NCB is not dealing on title, my lord. They are out to prevent an offense that harms the society at large.
No, so what is the purpose of investigation? If investigation officer will not
No,
ascertain
my lord, these,
whose house,
my lord, these
why the contraband was kept
no,
there.
that is sufficiently
That
ascertained.
should
No, my
be
lord, they do
explained.
not,
Then
they
only
never
chain
deny.
will complete.
My lord, these plea that the house was not my house comes in 2 stages. First in the bail plea. Well, the bail plea is in the most cases taken care of by section 37 on A, B, and B.
So you are saying the ownership of the
No, that
house
has
is
been
not
ascertained. That is
essential.
ascertained by the record. My lord, it is not possible for every case after doing a search and seizure. Now, I go to the BLRO or the Gram Panchayat to obtain a certificate.
Even if serious case.
No, because that is not challenged. It is only here, the final stage.
That
before
is
the
not
appellate-
challenged before the trial court.
It will not be challenged to the trial court. That is why I told your lordship that only 2 case scenarios we find the challenge to the address is there in the bail stage and in the appellate stage. And they remain conveniently silent in the trial.
Yes. Next.
No, my lord, regarding, my lord, I will answer up to section 15. Kindly allow me to come back tomorrow. Now, my lord, your lordship has already answered the query. I can safely replicate it. And Supreme Court also, Honorable Supreme Court also
There are
says.
several
So
judgments
50,
on this.
section 50, when the house is being searched, it is nowhere required to comply section 15. Yes, if, as your lordship was pointing out, if the my person is searched, and accidentally, incidentally, even some amount of contraband is recovered from my person, section 50 have to be complied to the letter. But if nothing is found, but it is found from the enclosed periphery of the house, 42, 43, either of 2 will come into. So compliance of 50 is not at all relevant over here. Another point was taken by the appellant is that the gazetted officer being a part of the raiding team vitiates the proceeding. My lord, Supreme Court, Honorable Supreme Court in several cases has clearly laid down that no. My lord, I will be relying in this and I will give you lots of Rajasthan, state of Rajasthan with Ramchandra, because here both the questions were answered by the Honorable Appeals Court. That section, where section 50 needs to be complied, and whether the gazetted officer being a part of the raiding team vitiates them. So one of the two counts, appellant's case falls. There is no ambiguity in the residence. Nor is the case that any alibi put up by the defense that we were not present that day. My lord, the appellant has laid a very bulk of weight on the discrepancy of the evidence of the two independent. We have read their evidence to some extent. I will once again take your lordships, trouble your lordships to take your lordship there. But we have also to see, my lords, that during the trial, did or did not the trial judge rely on these two witnesses? My lord, there can be two situations, if I am permitted to bring out a metaphor. That one, the trial court relies on the evidence of the hostile to these two independent witnesses and come to a conclusion. But my lord, he is also at all liberty to discard these two evidences and come to a conclusion. No, my lord.
This is out of two, one was declared hostile.
My lord. But we might come across a situation in the judgment of the trial court, my lord, where the trial judge relied on other evidences on record to prove the surgeon's nature. That is not irregularity, that is not part. As a trial judge, he did not find confidence, the evidence of the independent witness did not inspire confidence in the mind of the trial judge. I am not taking it into consideration. But there are other evidences on record which can prove that point.
What trial court has relied on?
My lord, trial court has not relied on these independent witnesses. He relied on different witnesses that came before the court and people and has proved the service.
Who are they?
My lord, no, it starts from page 92, my lord. Paragraph 7, lordships. Have it? Now let us dwell upon the evidence of the independent witnesses of this case. PW3 did not support the prosecution case as he categorically stated that he was unable to recall any incident in connection with this case and did not know anything in this case. He also refused to identify his signature on the notices issued under section 50 of the NDPS Act. My lord, pause for a moment. My lord, they were, for example, my lord, if I am permitted, in a particular given instance, there were 10 persons present. 2 out of them said, one said, I did not sign, I do not know,
that is my signature.
Another person said, no, I was made to sign. But 8 says, we saw them signing. So obviously, the one question that would crop up in the mind is, there is a fair chance of them being gained over. Now, my lord, a court of law will view a hostile witness in a particular way, gained over witness in a particular way, and I did not tell your lordships how to view evidence of a standing witness. He also refused to identify his signature on the notices issued under section 50 of the NDPS Act and on the search cum seizure list, but he identified his signature on his voluntary statement, which signature was marked as Exhibit 13. In his cross-examination by the learned defense counsel, he stated that he when signed on the said page, which was his statement,
Signature marked Exhibit 13 is?
13 is his statement of the witness.
67.
My lord, he's 67 notice will not go to the witness.
Exhibit 13 is?
My lord, even the paper book does not say what is
Yes,
P13.
Exhibit 13 is, my lord,
Exhibit 13 is signature of PW.
Signature of
Three on
PW3 on
voluntary
voluntary statement of PW3. Page 65, my lord.
65.
65. Wow.
Yes.
So, my lord, in his cross-examination by the London Defense Counsel, he stated that when he had signed on the said page, which was his statement, it was completely blank. So the appellant brought out a case that he was suffering from eye operation, he could not sign. Now he says, I signed when the page is blank. So he is himself contradicting. Thus, it is evident from the evidence of this witness that he clearly did not support the prosecution case a bit, for which he was accordingly declared hostile on the prayer of prosecution. PW4 stated that he was forcibly made to sign on a paper by BSF personnel at their camp in Gopalpur on the night of 22/1/22. He managed to identify his signature on the two notices and the search consider list, which was consequently marked as exhibit 9-2, 9-3, and 10-1 series. The same was of no value, as this witness denied the suggestion that he has made his signature in the house of Prashanta Mondal. In his cross-examination, this witness stated that he had put all these signatures in the BSF camp, which also clearly shows that this independent witness too did not support the prosecution case. So we can safely conclude the London trial judge did not rely upon these two witnesses to come to a conclusion about whatever conclusion he had reached. In the appeal, we had to show the appellate court, honorable appellate court, the judgment suffers some defects, which goes to the root of the judgment. The appellant was trying to canvass a point that the London trial judge convicted the accused persons of the appellants basing on this faulty witness. But while we read the judgment, my lord, we find a contrary view coming out. But he says, no, this doesn't help the prosecution case. PW5 was another important witness. Now, there is no challenge to the evidence of PW5. But in that regard, my lord, as I was hearing my learned friend, certain portions of the evidence that was not challenged has gone into stripped. Like, as I pointed out, there was no challenge to the identity of the PO in the trial. Another discrepancy was brought out in the evidence sheet of 21 and 22. But again, my lord, that is a very minor discrepancy. We do not know whether it was typographical error or really stated by the witness, because the cross is conveniently silent on this point. The London Defense Counsel should have hammered it in that you are saying 21/1/22. It was not on 21/1/21. You are no. So that was a slip, my lord. And even if it is not a slip, it doesn't vitiate the case. The appellant was trying to make out a case that there was a search and seizure, but it was not proper. It is not a case where there was no search and seizure. But I am trying to distinguish, my lord. He is saying that there was a search and seizure which was not according to law and maybe according to his wish. And to buttress his case, he says that these two witnesses denied their seizures. But he does not show the court, the appellant does not show the honorable court that the trial court had blindly relied on these two evidences to come to a conclusion that the search and seizure was true. On page 31, internal page 31 of the judgment of the Honorable Learned Trial Court, my lord, paragraph 7 I was reading. In his cross-examination by the Learned Defense Counsel, he stated that when he had signed on the page, which was his statement, it was completely blank. Thus, it is evident from the evidence of this witness that he clearly did not we have completed it. Now, my lord, PW5, if you will not see, kindly takes paragraph, page 32, internal page 32 and 93 of the paper. PW5 was another important witness in this case. He deposed that on 19/1/22, he was directed to act as investigating officer in this case by his superior, who was the zonal director of NCB KZU. If any seizure was affected, with direction was contained in NCB 1 form, after which he, along with the NCB team comprising of PW2, PW7, and PW8, arrived in Falakata on 21/22, stayed overnight at the office of SSB Falakata. He further deposed that on 22/1/22, at around 8 p.m., he got a message of the seizing officer PW2 that they had seized 690 kgs of gaja at Magalpara village, after which he has rushed to the house of the accused Prashanta Mondal and Arjun Mondal and found PW2 along with 2 independent witnesses, PW3 and PW4, with the accused person present in the said house. He also deposed that he took over 690 kgs of gaja contained in 49 gunny bags, which was sealed and labeled, seizure list and notice under section 50, and 1 envelope of PW2 from it was by way of taking over document which was prepared by PW2 in the said house, which articles contain the signatures of the accused person, seizing officer, BSF officer, and 2 independent witnesses. He also deposed that on query by him, the accused person had confessed the said gaja was recovered from their house in their presence, after which he gave them notice under 67 of the Act, and thereafter recorded the voluntary statement of the accused person on the same day in the office of 47 Battalion BSF, in which the respective accused person in the respective statement admitted that they had stored in gaja in their house, after which he arrested them on the basis of previous seizure and their statement. My lord, even if we disregard their statements of the accused, because we know self-incriminating statements cannot be taken into consideration, my lord.
So actually,
My landed friend was indicating to the chain of events. Now, my lord, storing gaja is a very important triggering point of events, which was not denied. That itself is an offense.
so actual seizure was made on 22nd. 22nd, yes.
No, my lord. Importantly, this witness stated that thereafter he conducted personal search of the 2 accused persons in the said office, during which documents of respective accused persons like arrest memo, notice under section 50 and notice under section 67 was recovered from the respective accused persons, after which he kept those documents in separate sealed envelopes marked D1, D2, and thereafter handed them over to BSF personnel present there along with the seized gaja for safe custody. As my lord was indicating that during the personal search of the accused person, only certain documents were recovered. So 50 does not come into. In this respect, it is to be noted that this personal search was done after recovery and seizure of gaja from the PO house, and after prior separate notices under section 50 of the NDPS Act was served of the accused persons, and so this personal search in the PSF office cannot be construed as a search to recover contraband from the possession of the accused. At the base can be held to be a search for checking whether any arms or other incriminating materials was in possession of the respective accused person before giving them in custody, for which communication of right to accused person as under section 51 of the Act was not needed. My lord will also appreciate one fact. These types of search it now become a routine. But lot of persons before they are handed over to custody, just for also drugs, personal drugs, medicines. Those are not allowed in the jail custody. So this does not mean that it can be compared to and put at par with the search and seizure procedure as contained in the NDPS Act section 50. It was after everything was done, a frisking was done to find out if anything more they are hiding. And only the certain documents were recovered. In possession of the respective persons before giving them in custody, for which communication of the right to the accused person under section 51 of the act was not needed. This witness deposed about the safe custody of the alamas and also deposed about complying with the requirements of section 57 of the act, sending report about the arrest of the accused person to his official superior PW1. He also deposed cogently about complying with the requirement of 52A of the act, getting the alamas verified with the inventory prepared by him by a jurisdictional judicial magistrate, during which the magistrate had also drawn 98 samples of gaza in his presence from the alamas. He also deposed that he had sent these samples to the concerned laboratory for its chemical analysis and duly collected the said report after it was done, and had also obtained the statement of independent witness PW3. It is important that the witness identified both the accused person present in the court dock to be the two accused person whom he had received by of taking over from PW2 at the PO house along with the seized ganja. He also proved his signature on the taking over receipt, exhibit 11/1, and over the test memo prepared by him, marked exhibit 3/1. He also proved the voluntary statement of the independent witness PW3, which was scribed by him, marked exhibit 13/1, and he also proved his signatures on the various documents prepared for safe custody of the alamas, which were also marked exhibit in this case. But this is the gentleman who had come before the court and said that one of the witnesses, Ajit Biswar, he signed in my presence. Now that portion of his evidence was not demolished in court.
Where is that?
My lord, your lordship may take it from 1, 2, 3, 4, 5, page number 24, fifth sentence from the bottom. A little further up, my lord. Thereafter, we were accommodated 24 of the paper, my lord.
24 people.
My lord. HON'BLE Kumar Sadhukan. My lord, has
He is the intelligence officer.
my lord, kindly takes it 1, 2, 3, 4, 5, 6, 7, 8, 9, 10th line from the bottom. Thereafter, we were accommodated 17 BNSS Falagata on 22/1/22 at about 8 hours. One BSF constable came at 17 BNSSB Falagata and conveyed the message of seizing officer of NCBC Raju Mukherjee that they had successfully seized 690 kgs of gaja located at number 2 Magpala under PS Sitalkuchi, Kujbihar, and I reached at the seizing spot at around 9 hours on 22/1/22. On reaching the spot, residence of Prashanto Mondal and Arjun Mondal, I noticed seizing officer and BSF team, two independent witnesses, namely Ronen Sarkar and Ajit Biswas, to be present there. Prashanto Mondal and Arjun Mondal were also present inside the house. Thereafter, I took over 690 kgs of gaja contained in 49 gunny bags. Seizures notice under section 50 and one envelope marked as D from the seizing officer Raju Mukhopadhyay by way of taking over document, which was prepared by Raju Mukherjee. All were sealed and labeled, were intact, having the signature of the seizing officer, two independent witnesses, BSF officers, and two accused persons, namely Prashanto Mondal and Arjun Mondal. Thereafter, I asked both Prashanto Mondal and Arjun Mondal regarding the seized contraband, and they accepted that the said 69 kgs of gaja was recovered from their house in their presence. Objected to. I issued notice under section 67 to Prashanto Mondal and Arjun Mondal, asked them to appear forthwith on 22/1/22 at the office of 47 BNBSF. They replied that they did know the office and requested us to take them to the office. This is typing mistake. Accordingly, I took them to BSF office. On reaching at the BSF, I handed over 690 kgs of gaja. Now I need. My lord, I beg to differ. I think my lord Raju Mukherjee is here. My lord, I will come back to the evidence after I finish the paragraph. He also proved the voluntary statement of independent witness the PW3, which was scribed by him, marked exhibit 13/1, and he also proved his signature on various documents prepared from the safe custody of the Alamas, which were also marked exhibits in this case. It is apparent from the evidence in chief of this witness that he fully corroborated the prosecution case. In his cross-examination, this witness admitted that he did not prepare a rough hand sketch map and index of the PO, but this admission does not cause any dent in the prosecution case, as most of the prosecution witnesses, including this witness, himself had narrated that the PO was the house of the accused person in Mahabala. He also admitted he did not see any document to verify the ownership of the house, which admission does not hold water to demolish the prosecution case, as the ganja was recovered and seized in the presence of the accused person in the PO house. He also admitted the arrest memo prepared by him did not bear signature of any relative of the accused or any respectable member of the society, which otherwise is non-compliant with the mandatory requirement of section 41B of the CRPC, for which prosecution cannot be thrown out. Thus, it is apparent the evidence of the IO also supported the prosecution case. So mainly, my lord will find that the trial judge was not leaning on to those independent witnesses to come to a conclusion. Well, kindly allows me to come back tomorrow at 10:30 or 6 of this.
You have covered more or less all the points.
Well, all the points. I will just want to finish it up by handing over my written notes on the justice at one go. And my lord, actually, I find it very difficult now to stand quiet.
Oh.
I am very sorry for that predicament, my
No,
lord.
it's all right.
My lord, we'll start right from here. Careful. कब बोला?
Take down pretty.
पहले तो लोगों ने बोला.
On submissions made on behalf of the appellant. Written notes of argument filed by the appellant. Report today be taken on record. Stop. Learned raised GI his argument but does not conclude the same. List tomorrow.
But actually, my lord, ganja is now being considered very seriously by the medical experts. He said that it cures certain kinds of cancer, including brain cancer.
Raja.
I'm serious, my lord. In America,
Tried it.
I guess so, my lord, because he is so confident.
I heard that.
Here's evidence we cannot consider. Actually, my lord, the marijuana is not now legally and under the government supervision being cultivated in US. This is the cancer, sir.
Copy served.
In this case, let us permission under section 324, imprisonment for life. Sentence for 6. Embassy kindly grant the Case number 7, the earlier rejection order. Direction. Lordship, 1 year.
No, it cannot be prepared because the records were incomplete. The trial court records were found incomplete and defective and it was sent back. It has not been received. We'll expedite the process and hear out the appeal.
This is an application for suspension of sentence. Petitioner renews his prayer for suspension of sentence on telling that earlier on 11/6/2025, his prayer for suspension was rejected. However, there was a direction to expel.
State and contesting. I have prepared list of events. And one visiting also.
What about the instruction regarding
Honoring of the check.
deposited?
They have not deposited. Yeah, we have already handed over. We requested to pay cash, they requested to give us check, we handed over check. Now, if they don't pay cash, we are not responsible. That way we
The
request.
check was not deposited in the bank.
The college had received it.
Yes,
And the college administration, the governing body decided that
Not
it
to
would be,
encash it.
no, it would be, for the legal aid purpose, it will be used.
the paper.
No,
Then?
the amount,
Where is the
5,000,
amount?
5,000 and 5,000, two checks were issued in,
Where is the amount? Now it is only paper.
it is the only paper.
Then that
It
means
is-
you are not interested.
Because the amount, my lord, we will utilize it for the legal aid purpose.
Why did you get it?
You can
My lord, that was the
utilize that
court's
money.
order, my lord, because they have repeatedly, it has not been, my lord, we have accepted.
Anyway, that is up to you.
You have no any objection.
Yes, my lord, no, nothing.
He doesn't want it also. Yes.
Basically, it relates to, my lord, a society which is a non-profit organization. My lord, the diversion of the assets of the society by a beneficiary trust. My lord, your lordship, my lord, I will demonstrate during the course of my argument that there is a systematic layering and siphoning of funds of the society by the beneficiary trust. My lord, in brief, my lord, I have handed over the my lord, list of dates. My lord, there's a checkered history, I'll tell your lordship. 2009, my lord, the society was formed. The society is named, my lord, Pranasha. My lord, 2012, the society decides that it will run a college, my lord, an educational institution, B.Ed Training College, my lord, in the name and style of Alipurdwar B.Ed Training College and Institute. My lord, 2013, it was granted affiliation by the NCT, and 2014, my lord, the society was permitted to start DLED course. 2015, my lord, recognition was also granted for DLED course. So everything was fine, my lord, till 2016. By NCT, everything was regularized till then. My lord, in the year 2018, my lord, this petitioner, who is the appellant, who is before your lordship, my lord, he was the president of the governing body at that point in time. My lord, 2018, the secretary of the general body, Mr. Upol Samanto, accompanied by two other members of the governing body, my lord, both of them forced this petitioner, the appellant, to resign from the office of the president of the society. My lord, August 2018, he get the information that after his so-called resignation,
his signature were forged, and certain manipulations, financial irregularities were being committed by the other members of the governing body. My lord, he lodges a complaint before the respondent number 4, my lord, who is the concerned university granting affiliation to the college. My lord, 2018 November, my lord, in compliance, in response to the said complaint lodged by the appellant, my lord, the university response to the said complaint of the appellant and said that amicable settlement was initiated by the university between the appellant as well as the members who are there in the present governing body. However, the Upol Samanto, the person who was running the governing body at that point in time, he did not turn up for the amicable settlement, and ultimately in 2019, ultimately on 27 November 2018, the university says that we, since you have not come for amicable settlement, we are reinstating the old governing body which was there prior to 28th of August 2018. That means the governing body in which the appellant was the president. So, after that, 2019, respondent number 3, Millard, issued a so-called notice. 3 is the Millard National Council for Teachers Education. This is the Millard professional body which grants recognition.
Density represented. No,
Not a party.
what not?
No,
ANC
it is a party. Respondent number 3.
Yes, important party.
Yes,
Did you serve?
yes, we have served.
Did anybody appear before the trial court?
No. But NCT was NCT to aage represent korthila Rajit.
But for the purpose of the present dispute, probably NCT is not required. Not required.
Baba Saheb Ambedkar Education.
Even they are not required. They were represented before the trial judge.
But they are regularly made parties as because they are regularly authorities.
Alipurduar B.Ed Training College is here.
Yes.
And Ashwini Chaudhary Education.
Yes,
Officer.
Yes.
The state is.
State is here.
We are members there for respondent number 1 and 7 to 10.
All right. So, Millard, in 2019, the NCT, due to several mismanagement and irregularities, Millard, the NCT has withdrawn the recognition.
What is the problem, tell?
Millard, the problem is, while this mismanagement was going on in the college, Millard, subsequently in the year 2002, a trust comes into picture. Millard, the trust purchases the society. The assets of the society was valued at 5.78 CR back then. Millard, the assets were sold at the value of 1.15 CR. The money was paid individually to the members of the society. Not the entire money, not even the 1.15 CR. Millard, as per the only 30.
So much money come.
Who purchased?
Millard, the trust, beneficiary trust, Ashwini Chaudhary Educational Trust.
Yes, how could the trust get so much of money? Who paid this money?
Millard, the
Was it-
trust is earning, probably the trust is earning, trust has money, so it has decided to purchase. First of all,
What trustees?
Millard, Mr. Joyjit Chaudhary is the managing trustee. That college, the trust, it runs many colleges, so probably it has money, Millard. That is not the issue here. The issue is, Millard, how it has purchased, whether the purchase is legally tenable or not, whether a society can be sold or not. Millard, there is a valid.
Why these things we gone into in the.
Millard, that is the question. Millard, society, Millard, if I am the member of a society, Millard, the assets of the society is not my personal property. Millard,
Registered under Society
Registration Act.
So there is a provision.
That has been done, Millard. That is why I'm saying, when I was going through all this, Honorable Justice Rajshekhar Mantha, Millard, had passed an order earlier in a repetition where the register of the farm societies and non-trading corporations, Millard, he was directed to look into all these aspects and pass an order. Millard, after looking into all these aspects, he says that there is no constitution which regularizes the meeting or which actually deals the meeting, and henceforth a new committee has to be formed by calling elections. And till then the DM will supervise the affairs of the college.
That order has been complied with?
That order has been complied.
Yes.
Yes.
Yes, then where is the problem?
Their order, my lord, another order passed by your lordship, my lord. WPA 7, WPA. Wait, no, for it. My lord, kindly come to P2, Annexure P12 once, page 72. My lord, there is a checkered history. Page
Go
7.
to the history, tell me what is the immediate relief?
Immediate relief, my lord, we are praying for an investigation into the affairs of how the entire money has been paid and how this, how the society has been sold and where the money has been paid.
But then the registrar has, just now you pointed out the registrar has called for a meeting.
Register has not gone into the legality of the sale. He has only gone into the management and the mismanagement which was alleged back there. My lord, page number 72.
But who is the Article 12 authority here amongst the?
My lord, I am coming, my lord,
Let him satisfy that first.
my lord, to
Against
order an
whom are we to
investigation
rely?
into a sham transaction whereby, my lord, the assets of a society is, my lord, diverse to the individuals of the society. My lord, this is the criminal offense. And if there is a criminal offense, there has to be an investigation. My lord, we have prayed for investigation before various authorities since the authorities have not acted upon
Who
our.
was the impugned order?
My lord. Page number, my lord, before that, kindly see, my lord, page number 72 once. This is order dated 18/2/2020. By virtue of that order, my lord, we have preferred complaints. Page number 74. Paragraph. Page number 73, paragraph 2.
Page number 70?
75, paragraph 2. This is the application.
It was a DM. 72.
My lord. 72 is the start of the order, my lord. 75.
Say, Honorable Sarkar, respondent number 6 intends to, alright, of the party to be intended to make the representation into the DM. Was
Yes,
this done?
yes, that was done.
That was done, but nothing is done.
That was done, my lord, but no action, my lord, by the district magistrate thereafter.
But that is not the cause of action of the writ petition.
Why are you so excited? You were appearing for the state in that matter.
No, no.
Yes, 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 yes.
And now you are appearing for a private party. Yes, how can you appear? How can you appear? Your appearance is recorded in page number 72.
No, 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 it slipped out of my mouth.
Then you cannot appear in the matter.
No, no, I won't.
Yes, then.
Look, page 72.
Yes.
My lord, thereafter, complaints, my lord, as per the liberty granted, complaints were preferred before the district magistrate. My lord, the complaint was not acted upon by the district magistrate. Even before the other authorities, my lord, we have preferred complaints. Nothing was done. My lord, before the SP, lastly, my lord, we have made a complaint before the SP saying that this is totally a sham transaction, my lord, where the assets of a society, my lord, has been divulged to the members for getting illegal gain, both by the beneficiary trust as well as by the members of the society. Nothing done, my lord, we approached this honorable court before the writ jurisdiction. The honorable court, my lord, denied us relief, my lord, by saying that.
What was the prayer in your writ petition?
My lord, with respect to investigation. Lord, there were other prayers also. We are not pressing any of the other prayers except investigation.
We have given the writ petition. Where is the writ petition?
My lord, writ petition we have given, my lord, by way of supplementary evidence. My lord, even the petitioner was handed over with 2 checks. My lord, we have that check we have annexed in the supplementary evidence. Those checks have not been encashed. That has been kept intact, my lord, as it is.
Page number 193, supplementary.
My lord, page 193 is the checks, my lord, we have Annex the photocopies of the check. 2 checks of 2 lakhs each.
And it's about 3 applicants.
Where is the order in PO?
My lord, that is,
Page number 18. Certificate copy.
certificate copy lo na?
204, 11.
Yes, 204, my lord, yes,
204.
yes.
You have already filed complaint for the Supreme.
Superintendent of police.
What happened here?
Nothing happened. But agreed by that, my lord, we are before the honorable court.
Where is your complaint? Which page?
My lord, page 196.
96. This was in 2022.
Yes.
We are in 26 now.
My lord, the writ petition was filed in 2024.
Thereafter, we increase both the regulatory authorities.
Your case is only undervaluation. Is there
No.
any direct
No.
allegations regarding
No, my lord.
misappropriation of
No,
fund?
that is why, my lord, we are aggrieved, because that is the reason, my lord, the writ court denied us relief. It's not about undervaluation, it's about diversion of funds of a society to members of the society as well as to the beneficiary trust. My lord,
Did
this
you
is not a
file- did you-
personal
did you
property, my lord.
file-
One
no,
thing,
no, did
if
you-
I am,
Did you file any document of transfer of?
yes,
money
yes, deed
from
of
a-
conveyance.
Deed of
Deed of
conveyance.
conveyance is annexed.
Deed of conveyance, number of
Deed of
checks.
conveyance is registered document, that
My
amount
lord,
is
deed of
already
conveyance
reflected
cannot
in
be
the-
registered. That is the main question. How can
Then
a
it's not
trust?
registered.
It is a registered, it cannot be registered. My lord, a trust cannot purchase, my lord, our
So
society.
how writ court can entertain that?
We are not into the deed. We are saying that this is entirely a racket, my lord, that
Consideration.
has done the entire thing. The entire thing needs to be investigated.
You have
But
the
this is a
direct
systematic,
allegation.
this is
No,
a
you have to-
systematic economic offense, my lord, which requires detailed investigation.
All right, just wait. Mr. Triple H, is there any response to page 196?
No, most in all probability, no, thereafter the order of the writ court came and the writ court was of the opinion.
Yes.
Thereafter an order of the writ court came and the writ court was of the opinion that order is impugned here in my lord.
Yes.
If there is a direction that is given by this court, we will look into it.
Assuming no direction is given,
What-
2022, there is a complaint before the SP. The SP has not taken any steps. Why? What was the reason for such complaisance?
No, I need to be sure about it. I'm not that sure.
And what is the stage of that FIR?
Nothing. Is a
Nothing-
complaint.
nothing has been done.
Nothing has been done. Nothing has been done. In CT, there is also a complaint in page 200. This is also not very looked into.
149, 153.
From page 149 to 153, my lord, the checks are annexed.
In the name of building.
143 to 149. 143.
149 to 153.
149, 150.
Checks,
In the name of the individual members.
And in the name of the society also, 2 checks only. Amounting 32 lakhs.
That check amount is telling it the conveyance deed.
No,
No.
no. The memo of consideration is also not mentioned in the deed.
in the deed.
First of all, the deed is illegal. Even then, the memo of the mode of payment is also not mentioned there.
how was it valued and what is?
That
the
is
stamp duty paid?
that is what, my lord, this needs to be investigated. This is entirely a sham transaction. Whether there was any change of hands, also, my lord, we do not know. So this requires to be investigated. This is the economic layering and then siphoning off of funds.
If there is no offense, only
Do you think 196 is a complete representation and all details are there?
All details are there, my lord.
Are you sure page 196, 197, 198 is all right?
Yes, my lord. Till 198, 196 to 198.
Your contents are sufficient.
Yes, more or less, my
Are
lord.
you verified?
Yes, yes, my lord.
Bring a report on this, page 196.
My lord, on the college, my lord, let me, my lord, edited the few, my lord, the orders. Education.
We are not passing any order, it's only the response to 196.
True, my lord, but before that, my lord, I will just, which has been annexed in the, my lord, the appeal, I will refer that, my lord. First, not beyond that, my lord. Lord, kindly come page 54
Of
of this appeal, my lord, can one application.
One, the say, my lord. Well, Mr. Chaudhary is the president of the college for now, so my lord, he is appearing in robes, my lord. I object.
No, my lord, I am the college. College is being represented by, my lord, the principal. Kindly see the principal.
It's not the individual party over here.
Yes, college is a principal.
The complaint may be against him.
Maybe.
But then the, he is not an individual party in the report. That is the reason.
My lord, that is the reason, my lord,
Yes.
as the trust with the individual name. This is the reason, my lord, I did not.
Page 54.
Page 54, my lord.
Yes.
My lord, if this order, my lord, the very relevant portion, then, my lord, your lordship will understand, my lord.
If I can have my lord,
The-
a moment on page 72, my lord. He
Well, just-
appeared for the respondent number 3 and 5.
Who?
Jajit Chaudhary.
Yes, for NCT, the same. NCT, yes,
And
the
now he is-
respondent.
And now he is the college.
Yes, the same. No
Yes.
conflict of interest, my lord.
Conflict of
Maybe.
My lord.
May not be conflict of interest, but two different parties you are representing now. You cannot do this in this way. Respondent numbers 3, 4, and 5 in WPS 756. Respondent numbers 1, 2, and 3. This is NCT.
Yes,
Exactly, my lord.
yes.
how you
Exactly.
can,
Now you are representing the college.
College.
That means the college, the
And the
NCT,
NCT are same.
all in the same line.
conflict,
My lord,
All in the same
my lord,
line.
it may be. It may be. If my lord sees that there is a, my lord, the collusion or there is any, my lord, a deviation. What is the NCT status and what is the college status?
It
NCT,
cannot be the same under any
the
circumstance.
NCT is the regulatory body. And the college is, my lord, the imparting the education.
How can they do be
My lord, there is
Let
no
me also-
college.
let the attendance be marked and a reports be called for. We will give the report.
This is what we want. We want to. I have seen it. Even in other orders, your appearance is
Is
recorded.
there? Yes.
Just as I saw Mr. Ghosh's appearance there. And
you have
without
to
going into
check.
everything, anything.
Then, my lord,
Yes.
then, my
Call
lord,
for a
then,
report.
my lord, that both me and because under my instructions, the advocate instruction, Mr. Ghosh is appearing. I will return and the
He has already
No,
retired.
no, even I am withdrawing my appearance, my lord, in 2023, my lord, I was burdened with approx 750 briefs.
All matters you are there.
Yes, maybe, maybe.
Yeah,
Even then,
That
with
may happen,
state
that
as of
may
now,
happen.
till now, there was no
but
conflict.
whenever
Yes,
you
yes.
came to know,
No,
But
but
once
I
you
am withdrawing my
appear-
it is
appearance.
apparent
No,
from
no
records,
difficult.
you suddenly
No,
cannot.
I
True,
won't.
my lord. If your my lord sees that the college, because at point of time, my lord, I address the on behalf of the NCT and my lord, the college, my lord, being so. Then also, my lord, if your lordship for the sake of the justice, but I will also even retire. Then kindly keep it Monday. We will new sets of lawyer will come, my lord.
Whoever comes in the meantime, later it is recorded.
My lord, report, my lord. I'd like to address something, my lord. If my lord can,
no,
call
no,
for any report.
what is the relations between that or this?
Malad.
There is no relations
No,
between that.
true, my lord.
That is
I have,
different
but
issue
my lord,
that
no.
complaint
Calling
has
for
been
a
made before the Supreme.
calling for a report, no issue.
Eh.
No.
Don't stand in the way of calling for a
No,
report.
I am not saying calling for a report. My lord,
We
my lord,
always-
I wanted to place an order which has been passed by the honorable court here, my lord.
Whether
We'll see
any,
it on the next day.
we
Right.
only want to see
Right,
whether
right,
anything,
right,
anything
right.
steps has been taken
Right,
by
right.
the police authority.
They have to get lawyers from the principal bench now because everybody must have been
Everyone.
appearing for any of the parties. Mr. Jyoti Chaudhary appears for the respondent number 3. 3 and 4. 3 and 6.
Malad 3 and 6.
Now 5 also you are.
No, Malad, for college, just a second, Malad. Yes, no, Malad. 3 is the NCT. Here I am not representing NCT.
5 and 6.
You represent 5 and 6.
I represent the, no, 5 only. 5.
You represent 5. Mr. Ghosh was representing 6.
6.
6.
Represents the respondent number 5 and Mr. Vikram Ghosh represented the respondent number 6. So, on the basis of the documents annexed to the application for stay, it appears that both the learned advocates represented other parties in the previous proceedings.
Relating to this.
Relating to the present case. Both the learned advocates seek leave of the court to retire. Leave sought for is allowed. The appellants allege misappropriation of funds of the college. A complaint was lodged before the superintendent of police, Alipurduar district, in May 2022. The allegation is that no steps have been taken in response to the same. The learned AAAG is directed to obtain a report from the superintendent of police in response to pages 196, 197 and 198 of the stay application. List in the next circuit.
Timely.
Next week. Report. How can that do?
Next week,
You cannot be so impatient. It's been some time from 22, now we are in 26. So many years have gone down, and by so many days, you think the SP will be able to file a
That's
let a report
Lord.
come, a proper report.
Malad. I'm ready.
That report will also go. Let a report come,
Malad.
let's see what happens.
Yes, sir.
Item number 6.
For your,
The respondents?
it's the customs authorities, Millet.
Yes, Mr. Boni.
Yes, Millet, he was there. Ekbar bolun. Millet, may I place the facts? Millet, what has happened here is, Millet, initially a confiscation proceeding was started against the appellant. Confiscation proceeding, Millet, was carried into an appeal before the tribunal. The tribunal quashed the entire proceeding. It was challenged before the honorable court. The honorable court upheld the judgment. And then the department carried an appeal, an SLP before the Supreme Court, which was also dismissed. Now, Milord, so thereafter, Milord, there was no confiscation proceeding. But, Milord, when the Honorable High Court, the division bench considered the judgment of the tribunal, the division bench directed the refund of the value equivalent to the seized goods. Because the seized goods were areca which had already perished by that time. Therefore, the department was directed to refund the amount equivalent to the confiscated goods. Now, Millard, even after that order, Millard, for a prolonged period of time, that amount was not disbursed. Millard, an application was taken out before the Honorable Court. In that proceeding before the High Court, wherein the judgment of the tribunal was tested, an application was taken out for immediate disbursement of the amount, compliance of the order, and Millard, for award of interest, since the amount was not released since 2016.
16.
Not 16, Millard, from the date of the judgment. I'll place the Millard, the documents, Millard, in a while. Now, thereafter, the Honorable Court did not entertain the application. The Honorable Court left it open.
Relegated to the statutory appellate forum.
Yes.
Where is the problem?
I tell you, Lordship, what is the problem. Millard, when that application was not entertained by the Honorable Court, the Honorable Court noted that it is open for the petitioner to take appropriate recourse in law. Now, Millard, a writ petition was preferred, claiming the interest amount. A writ petition was preferred. During pendency of the writ petition, all of a sudden,
Principal amount was paid.
principal amount has subsequently been paid. It is only the interest.
After direction of the court or themselves?
During pendency of the writ petition, after this order was passed.
After
In
this
between,
order
when
was-
this appeal was preferred, the principal amount was paid.
Without interest?
Without interest. The writ petition was preferred, the subsequent writ petition only for the interest component. Because the Honorable Court, the division bench earlier said it will be open for the parties to take appropriate recourse to law. Now, during pendency of that writ petition, insofar as the interest amount is concerned, the customs authorities passed an order. The customs authorities passed an order. That order was treated by the Honorable Single Judge, which was subject to correction, as an original order under the Customs Act, which according to us, Millard, is not the correct view, because it was only pertaining to the interest and on the basis of our representation that I should be paid interest.
So that is the administrative order.
It should not be, Millard.
Not be.
It should not be an administrative order, because for the purpose of treating an order to be an order in original under the Customs Act, there has to be a proceeding. The earlier confiscation order was an order for which there is an appeal available under the Act. But pursuant to the order of the Honorable Court, when we made a representation, they kindly disbursed the principal amount and the interest. There was no reason for the authority to pass a document or issue a communication in the form of an order.
Sure.
Yes, Millard. Millard,
February 2026.
Millard, first, your lordship would take, Millard, the order of the division bench, wherein the tribunal's confiscation order, Millard, was set aside, and the amount was, Millard, directed to be disbursed. Page 175, Millard, of the stay application, the operative portion. The last paragraph. May I place, Millard? Now, coming to the issue of return of the goods, admittedly the goods are perishable in nature, and the goods were seized on 1st March 2016, and the question of returning the goods to the respondent in Casta 22 of 2022, that is, Millard, the appellant before your lordship, at this juncture does not arise, as the goods would be unfit for human consumption and will be against the public interest to direct return of the goods. Therefore, to that extent, the order passed by the tribunal stands modified, giving liberty to the respondent in so and so, namely so and so, to seek the payment of the value of the goods by making an application before the concerned authority. And if such application is made within a period of 30 days from the receipt of the server copy of the order, the said application shall be processed in accordance with law. With the above observations, appeal are dismissed. Now, pursuant to this, Millard would just turn over. Millard would find, Millard, several representations were made, series of representations, Millard, nothing happened. Then, Millard, we preferred an application before the Honorable Court itself which was Millard General Application GA3 of 2023 at page 193,
Which got dismissed.
which got dismissed, but it was kept open. Millard, the last line.
Yes, to invoke remedy available in law.
Available in law. This Millard, on the strength of this Millard, we preferred the second writ petition, seeking disbursement of the amount along with interest.
Where from does the issue of interest come?
Millard, due to the delay, I am covered by a judgment of the Supreme Court. Whenever a confiscation proceeding is set aside, interest has to be paid. Millard, I'll just place the judgment in a while, Millard. Now, thereafter, Millard would kindly turns over. On 13th, the writ petition was taken up on 13th January 2026.
Are you coming to the impugned order?
No, Millard, not the impugned order, prior to that.
13th January, what is?
13th January is the order which was passed prior to the impugned order in time. 195.
Yes.
The Commissioner of Customs, Central Excise and Service Tax Siliguri will file a report on February so and so with regard to the compliance of the direction passed in Casta 27 of 2022. And this was Millard subsequently corrected. It was Casta 22 instead of 27. Now thereafter, Millard turns over to page 197. They issues an order in origin. They issues an order in original sanctioning payment of a certain amount, but interest was not awarded. And this order in original was treated by the Honorable Single Judge as a fresh adjudication order. And therefore, I was relegated before the appellate authority. Now, my short submission is that this order in original, even if it is captioned or formatted like an order in original, this was not an order of adjudication in accordance with the act against which an appeal would lie.
This is in compliance with the direction.
This is in compliance with the direction. So it should have been treated as a mere communication of the compliance. So the Honorable Court called for a report. Instead of submitting a report, they issued an order in original. And this, according to me, Millard, is not an order under the Customs Act, which is again appealable. Because the original confiscation proceeding has already been appealed against, set aside. The question remains quantification and payment of interest. According to me, Millard, the writ court was sufficient enough under Article 26 to award me interest.
But then, at the time of passing this order, the quantum had to be fixed. The quantification had.
The quantification was already done because, yes, there was a seizure list, there was a value of goods which was seized, and there was a scheduled value of the department itself. It was just a multiplication which had to be done.
So on the basis of that calculation, your money has been paid.
Money has been paid.
Without adding the interest.
The interest. Now, in the interregnum, during pendency of this appeal, this amount has been credited to my account. Without notice to me.
Show us that earlier quantification.
Yes, Millard. Millard, that Caesar list is probably not annexed, Millard.
Let us see the quantification.
Yes.
Tally.
It tallies, Millard, it tallies. The seized goods, Millard, is undisputed. 82.92 metric tons.
Of fecal nuts.
As on 1st March 2016. Yes, and they have, Millard, just multiplied it with the scheduled rate of the department.
And when was the payment made?
Payment has been made, Millard, recently, Millard, a couple of months back.
Well, in 2026.
2026, 2026. Yes, 2026. Northern Black judgment. Now, let us just relying on one judgment, my lord.
May I, my lord?
We will hear you. Don't worry.
Lord, I just relying on one judgment, my lord. এটা 2001 SCC 545 আমার একটাই 3 সেটই আছে ও দেখছি দাঁড়া আছে নাকি এই না আচ্ছা আচ্ছা মিলার দা para 5 last line
Page number? Three.
This is the contention, and Millard, the last page, 12% interest was granted. The last page, the last line. Even though the applicant has claimed interest at 21%, we do not think it proper to award interest at such a high rate, and considering the facts and circumstances of the case, it would be in the interest of justice if the respondent is directed to return the amount of rupees.
Yes, what is your,
My lord,
the quantification was done in 1st of March 2016 and the payment was made in 26. Why will the money not be paid along with interest? This is a simple question.
because my lord, kindly have a look
And
into.
interest is not the punishable, it is a accretion of the fund.
Yes, yes. They have, on earlier occasion also, they have filed an application before the division bench, honorable division bench, for interest. Kindly have a look into page number 193, my lord.
Millard, before,
One line.
Millard, Millard, before my,
Yes.
before my
And
learned
the
friend takes over.
That
The appellant
to release the amount, because
Yes.
Erika Nath was not there to release the amount, and the amount was released on 9/2/26 by the,
It was sanctioned. It was sanctioned.
it was sanctioned. Ultimately, it was
thereafter.
released. And
Why will interest not be paid? From 2016, the nuts were.
Millard,
there.
can I interject for 10 seconds, Millard? Just Millard, one more judgment, the concept of interest and why it should be awarded.
No, I said accretion of fund.
Correct, absolutely. Millard, the Supreme Court, Millard Justice Pardiwala's judgment clarified that why in commercial transaction, interest is must. Millard, para 13, 14, 15, 20, 22, 23, 26, and 27. 13, 14, 15, Millard, then 20, 20,
14,
15, 20,
26 and 27.
20, 22, 23, 26, and 27.
27.
Doctrine of restitution.
Show us at least one paragraph we can go into and
Yes, correct.
see, otherwise these are all judgments.
Millard, para 23.
23, interest in normal position on capital. Just tell us,
Yes.
the quantification of the betel nuts was made in 2016.
yes,
The money is sanctioned. The confiscation proceeding goes.
yes.
Money is sanctioned. In March 2016, payment in 2026, February or March, 10 years down the line. Why will interest not be paid?
During this period, they have filed several applications. They have filed writ petition, they have filed casta.
That is the proceeding.
Yeah, but regarding interest, there is a appellate forum. As per section 128 of the
Appellate
Customs Act,
forum for what?
appellate against the order in original which was passed
Where
on
is the order?
order on 9th February
This
2026.
is a mere compliance of the court's order. Can you treat this to be an original order?
Oh, it is titled as order in
May be
original.
May be
titled.
title,
What
a
is
caption may be anything. but you
Yes,
have
the
Moreover-
caption is misleading. This is merely in compliance of the court's direction. You've made payment of the value of the Erica nuts that you seized. Where is the interest? This is the only thing. Why he is required to go to the tribunal to get it adjudicated? And the law is well settled that if the money is held back for you.
My lord, initially they have never claimed for interest. And that is why a direction was made upon the customs authority to provide the copy of the application which was filed by them. They have not relied upon the document. I am with that letter dated 13th May 23. In view of order, kindly have a look into the order. Order of this court.
No, I'll just clarify here.
Yes, yes.
The coordinate division bench wanted to look at the first representation.
Yes.
Was interest paid for?
No,
No, never claim.
first representation
here is
in
the
order
document,
to
They have
ascertain
not annexed this
whether
document.
Tell me one thing.
Yes, Milord.
Here, the interest part has not been denied to you. Where is your prayer for interest? Why don't you apply before them for interest?
the interest was paid for before the
They
honorable
have
division
never
bench.
paid for.
Not before the authority.
Not before
Not
the
before
authority.
the authority.
Not before the authority.
Yes.
But now the writ petition has filed, Milord, a report was called for, Milord.
Report says that the money has been paid. You go.
Principal
over there.
amount has been paid.
You go and
Once
pray for
again, you
interest.
say,
Milord,
That is my submission.
since
my lord.
2016, Milord,
Your submission was something else.
Milord,
Submission, challenging this, he is not challenging this. He says whatever is there, the amount is already there, he only wants interest, let him go before.
But
the-
they
Milord,
never,
our
they never paid for the
application
interest.
was filed before the division bench claiming interest.
Division
Depart-
bench is not
depart-
grant interest, the
Milord-
division bench was not holding the money.
Milord,
with them.
sufficient notice to them that a person is claiming interest. Milord, since
In view of
10 years,
last-
Milord, I am
Yes.
deprived of the money.
There will be another argument from his side before the Supreme Court that he may have waived interest. Do not leave this open for the customs authority to go and pray over there. You start from ground zero.
if you are entitled, you will get entire interest.
Milord, the-
Have you been for the respondents?
my-
I'm sure you have made this.
Milord,
submission.
my only submission is, since a writ petition was preferred claiming interest, now, Milord, would it be, Milord, justifiable to send me back again, Milord, for a representation for interest?
His submission is to be noted that you never paid for interest before the authority. And there is no rejection from any forum that interest will not be.
No,
paid.
Milord, kindly also
Yes.
consider this, that when I made my first prayer for interest before the honorable division bench, even the principal amount was not disbursed.
Yes, and that
Division
is
bench
more
not
so the
directed.
reason that you should go there and not come to the court direct.
So, Milord, after
On
10
6th
years,
April,
Milord,
my
You may
lord.
say that it is predetermined. I am sure they will not grant any interest.
again another round of
Another
litigation.
round of litigation cannot help.
My lord,
Otherwise,
6th
the point of
April,
waiver remains.
order dated 6th
You get
April.
it.
Milord, waiver probably, Milord, I have never waived it. Considering the
Yes.
delay in
But you
disbursement,
never
Milord,
claimed it either.
it was not expressly claimed also.
Then how do you get out of this?
On 6th April,
Representation.
order was made for filing this annexure.
Milord,
Today I am filing
Milord,
this.
prior to, Milord,
Annexure, in their writ petition,
Milord,
they
just,
have annexed the only letter, but they have not annexed the earlier letter.
Or what?
Or whether any interest was claimed.
no,
or
Milord,
not.
interest was claimed. Milord, can you see,
Even-
Milord, page 127?
Whether
My,
interest was claimed or
Milord, my
not. That was the
representation,
contention of
Was
the
interest
coordinate
claimed?
bench.
interest claim, 127, prior to
That
filing
was
of the
the-
writ petition, 13 December 2024.
127.
Yes, 127 at page 131. Para 6.
Yes, 127.
131, Milord.
Yes.
This representation was considered.
And what are you showing? Did you see page 131? There is a prayer for interest.
কত? Page number কত?
আমাদের লাস্ট রিপ্রেজেন্টেশনটা রিটের আগে 127.
রিটের আগে
131, page number 131, last paragraph. 6, paragraph 6.
Para 6.
preferred the appeal. Challenging the judgment passed by the London Single Judge on 17th February 2026, relegating the petitioner to the statutory appellate authority for claiming interest of the amount that has been paid to
Thereafter-
the petitioner.
May I, my lord? They have in their page 131, they have claimed interest. Thereafter, they have preferred IA application before the honorable division bench.
That is separate.
And division bench
That is separate.
has
This is
rejected the
state.
pair.
What is your submission with regard to payment? Just now your submission was that
There
he
was
did
no
not
any.
make any prayer, but admittedly a prayer is there. Where is your response to that?
Thereafter, he filed the IA before the division bench, and the division bench categorically mentioned that no question of interest. My lord, kindly allow me to take further instruction.
Learned advocate for the appellant submits that the learned single judge considered the order of payment to be an original order. The order dated 9th February 2026, directive sanctioning payment was merely in compliance of the direction passed by the Honorable Division Bench of this court. Stop the same cannot be treated to be an adjudicating order appealable before the statutory appellate forum. On a perusal of the order, caption order dated 9th February 2026, passed by the Assistant Commissioner, Jalpaiguri Customs Division, captioned as order in original, is merely an order of sanction of payment, being the tariff value of 82.92 metric tons of betel nuts, within bracket, areca nuts, seized on 1st March 2016, page 207, check the spelling, under section 27 of the Customs Act, 1964. The entire proceeding under the Act stood dismissed by the Honorable Court, for which the money had to be, for which the tariff value of the seized goods had to be paid to the writ petitioner appellant, as the seized goods were perishable in nature and actually perished in the meantime. So, the only prayer of the petitioner before at the time when the writ petition was filed, the tariff value was not paid to the appellant. During pendency of the writ petition, the tariff value has been paid. The petitioner merely claims for interest to be paid on the tariff value. In support of the submission that interest ought to be paid, reliance has been placed on the judgment delivered by the Honorable Supreme Court in the matter of Northern Plastics, reported in 2001 SCC 545.
wherein the Honorable Supreme Court was pleased to direct the authority to return the amount with interest. Reliance has also been placed on the judgment delivered by the Honorable Supreme Court in the matter of Dr. Purnima, check the spellings, reported in 2025 7 SCC 269, wherein the concept of compensation has been highlighted. So, the court was of the opinion that the respondents could not have denied to refund the amount along with interest. The appellants have drawn the notice of the court to the representation which was filed before the authority on 13th of December 2024, praying for refund of the amount along with interest. So, the appellants only pray for a direction upon the authority for grant of interest on account of delayed payment of the tariff value. Stop learned advocate representing the respondent submits that the prayer for interest made by the petitioner before the Honorable Division Bench of this court was not allowed. Stop. It has further been pointed out that the appellant never approached the authority praying for interest. It has been submitted that the order by which the tariff value has been sanctioned ought to have been appealed before the appellate forum, as the same is an order in original. We have heard the submissions made on behalf of both the parties and have perused the documents annexed to the application for stay filed in correction with the appeal. So it is evident that the petitioner and the appellant did actually pray for interest before the authority. The same has not been replied. The appellant approached the Honorable Division Bench in the earlier proceeding after with a prayer for grant of interest after the appeal stood disposed of. The Honorable Division Bench, video order dated 14th February 2025, clearly recorded that the appeal stood disposed of by judgment and order dated 14th March 2023. So the application was filed thereafter. So the Honorable Division Bench observed that it will be that the appellants may invoke other remedies available under the law for awarding interest. So the issue of interest does not appear to have been adjudicated either by the authority or by the judicial forum. So no decision has been taken by any of the fora as regards payment of interest claimed by the appellant. So the submission of the respondents that the order dated 9th February 2026 is required to be thrashed out before the statutory appellate forum as the same is an order in original, cannot be accepted by the court. Stop. It appears that the said order is a mere sanction order of the tariff value. Stop.
In pursuance to
In pursuance, in compliance of the direction passed by the honorable court. Stop. The same cannot be treated to be an adjudication order appealable under the statute. Stop. The appellant does not dispute the tariff value that has been sanctioned.
in the year.
Sanction in respect of the seized articles on 1st of March 2016. Stop. 10 years have passed after the seizure took place and the payment has been made in the year in February 2026. Stop. Accordingly, the court
Discount. Discount could be.
In view of the discussions made herein above, the court is of the opinion that the learned trial judge erroneously considered the order dated 9th February 2026 as an order in original appealable before the statutory appellate forum. The impugned order of the learned single judge accordingly stands set aside. The respondent authority is directed to take a decision on the representation made by the petitioners, appellant, seeking interest on account of the delayed payment of the tariff value of the seized articles. A decision shall be taken on the prayer made by the petitioner in the representation dated 13th December 2024 in accordance with law and in line of the decisions referred to herein above. Decisions passed by the Honorable Supreme Court referred to herein above. At the earliest, but positively within a period of 8 weeks from the date of communication of this order. If any amount is found due and payable, the same shall be disbursed in favor of the appellant immediately thereafter. If the prayer of the appellant is rejected, then grounds for rejection shall be specified. Appeal connected application stands dismissed.
Item number 1.
With apology, my ladyship, I would like to state that the conducted advocate of this matter has been impaneled. So we need time to engage a new advocate for this matter. So praying for the next circuit.
Your Lordship, may I get your time to mention one principal bench matter, Your Lordship? Your Lordship has kept the matter to be heard on 29th, Your Lordship, but after this, Your Lordship is not sitting. Your Lordship, it's a reconnection matter, electricity reconnection matter. I'm praying for reconnection, Lordship. Your Lordship may kindly hear the matter, Your Lordship, any day as per your convenience, Your Lordship.
Vivek Tarukar. The advocate record is Rishita Chakraborty. Yes, but where is she? Today she was in court, but now I am. Let's call her.
Item number 2. Item number 2.
Short possible.
Item number 3.
My lord, I have been instructed to appear on behalf of the petitioner as the advocate on record is court number 4, my lord. My lord, on earlier occasion, so far as I have been instructed that, my lord, a copy of the petition was yet to be served, my lord, to the state, my lord. However, it was not done yet, my lord.
Yes, your ladyship.
My lord,
They have
copy of, my lord, copy of the petition is yet to be served, my lord. My lord, kindly keep it to
Your ladyship, earlier a restoration was filed by them. the
restoration
same
was
matter,
allowed, my lord.
Bail application. That was allowed. Now the bail application, petition, the application itself is not served to us.
It was earlier served, my
Not
lord, but later on it was, my lord, submitted by the state that the petition is not there, my lord. My lord, today in course of the day, my lord, I will give a copy to the, my lord, petition to the state, my lord. My lord, kindly keep it tomorrow, my lord.
Copy of the application is not the home state. It is from 7.
My lord. Deeply obliged.
Archie, the advocate on record is out of station due to medical emergency. Kindly fix it on Thursday. Next week on. The advocate on record is out of station due to medical emergency. Sayantan Bhomik. Yes, my lord, he have to go outside. First. Okay, my lord. Okay, my lord. Grateful.
Number 5.
My lord,
In this-
item number? Item number 5678, these are from the same police station. And on the last occasion, we have submitted that we have enclosed the memo of arrest. This is first matter, no? Page number P317, madam. And this is the certified copy. We are holding the original certified copy also. And as per the memo of arrest, which is a mandatory provision, the signature of the arrestee must be there, the accused person. As per the DK Basu guideline, my lord, it's a mandatory guideline. So that has not been complied. This is one of my submission, one part of my submission. DK Basu. Paragraph. My lord will find from the memo of arrest, nowhere the signature of the witnesses are there. But the counter signature of the arrestee, that is paragraph number 11, that is written for possessing and carrying contaminants ganja. His family members has been informed regarding his arrest, but the signature of the arrestee in the memo of arrest is not there. That is a gross violation. That is the main point of my submission. Paragraph 35 is very much clear now. And after this mandatory guidelines, all this prosecution, investigation agencies, they have started the memo of arrest, then regarding again information of arrest, which later came on my lord PCR. And moreover, the grounds of arrest has not been communicated, only in the memo of arrest, just below column number 11, it is written for possessing and carrying contraband ganja. Mandatory provision, my lord, the ground of arrest has to be communicated. Article 22 of the violation.
Worship, IO needs to be called for in this matter. It is there. What they are saying, there is no signature in the memo of arrest. So for that, IO needs to be called. Grounds of arrest is also not there. Not there, at least in the CD. This much I can say. It is not there in the case ID. IO needs to be called for.
But I am in custody for a long time, and on the last occasion, the prosecution, they have prayed for time, though the city was there. But I am languishing in there. On the last occasion, he has prayed for time.
Contraband articles that have been seized have been seized.
But whether if my arrest is illegal, my lord, because the guideline has not been followed, it's a mandatory provision. And moreover, my lord, if my lord goes to the FIR, the complaint of the case, my lord. Page number 11, my lord. My lord will find that is record. What has been recovered? Is recovered dried leaves. No, it's written dried leaves, my lord. All this is only starting from 1 to 1 to all the articles has been written at dried leaves. My lord,
With regards to the,
Kamal Singh Chauhan, filed an application for bail and then not pressed. This term was there in the very beginning.
which one?
Down that you were taking, the
Well.
signature was not there.
আরো কি করছে?
Down there as well. It was distributed in the earlier meeting.
No, the memo of arrest after we have been done. Probably আমাদের আছে।
আরো
But,
রিজেকশন
I
আছে।
think the council have missed that particular different matter, but because this is after we have applied for.
Also, with respect to the search and seizure, videography was done. It is there in the case study. Videography.
But
So for my satisfaction, Lordship, let it be on Tuesday.
My lord,
I'll
another
answer.
thing, my lord, another when they are asking, another thing is there, my lord. That is, my lord, we just go to the definition of ganja, my lord. That is in definition.
is in custody on 26th of December 2024. Submission of the petitioner is that signature of the hearing is not, has not been given and recorded in memo of arrest. The arrest is included. Petitioner prays for the learned advocate representing
Lordship, another inconvenience. In Sanju Kumar's matter, which is item number, Sanju Kumar. Lordship, item number 7. The last rejection was on 18th of March. 18th of March. Last rejection.
They're in custody.
18th of March 26.
26.
So 4 months back.
4 months.
Yes, what is the change in circumstances?
Change, my lord, in the bail matters, my lord, every day I'm in custody.
Every day, further action doesn't mean that every day is.
I'll have to come with some grounds, but
Compliance of the
one indulgence, my lord.
Report I have taken. I've got apple.
One indulgence, my lord. Lord, the CD has been produced and he said that his signature is not there at the memo. That's why report has been called. That much may be recorded.
Let the IO final.
Because my lord has asked for the CD, it's not.
এটা কোনটা এটা?
Getting.
এটা কোনটা?
Item number 6.
এটা লিখে রাখো এখানে। তুমি
6,
আসো
7, 8, 7, 8, 7.
হ্যাঁ, 5 এ লিখে রাখো।
Same.
Same. Same.
5, 6, 7, 8. Next one.
Item number 9.
Nine to 18. Want to pass over? Take this opportunity. Make submission. Never leave this type of opportunity. The golden opportunities at your stage. Right? Up to 18. Awesome.
Item number 19.
Second December 26th. And the report was filed on 27th February 2020. Allegation is that the provisions of 14 of NDPS recommend seizure, storage, sampling and disposal practice has not been on hearing the submission given and on refusal of the documents next to the application. I will be opinion that the petitioner has failed to overcome vigors mentioned in the 7th of the NDPS. Now mentioned seeking bail may be now in trial. Is not down to
My lord. My lord, may I not proceed this application?
Item 24.
Lord, here, number one, ground of arrest was not intimated. Number two, the contraband was seized from a vehicle. It has been alleged, but petitioner was just been framed. He was not the owner of the vehicle, private vehicle, four-wheeler. That is very much clear from the FIR. I have annexed that. And the violation of memo of arrest signed in Bengal. My lord? Quantity?
54 54 kgs of ganja.
Ganja.
$54.420.
My lord, ground of arrest, that was, it is in, he signed in Bengali, my lord. There is clear mandate, my lord. Supreme Court has repeatedly stated in different cases. Previously, it was in Mir Rajesh Shah. That was in another judgment.
My apologies, Your Ladyship. Page 21, ground of arrest is there, Your Ladyship. However, it does the other signature in Bengali and communicated in English. 29 minutes of the CD.
Ground of arrest has been mentioned.
Yes, Your Ladyship. But it is in Bengali. No, signed in Bengali, but written in English.
So, my lord, when it is written, my lord, it has to be in the language which he understands. This. My lord, the ground of arrest is even we don't get when I apply for certified copy, not even on the charge sheet. So it's not possible on our part to know whether it is existing or not.
That is a separate call of action. The ground of arrest is not being given to us. I mean, application.
But what is the use, my lord? My lord.
Further action to approach the court.
My lord.
Okay.
But approach is not our, not our. 20? 25. My lord, I am, if my lord be pleased to fix it on Tuesday, my lord. Tuesday. And 27 also, because charge sheet doesn't.
1 by 1 we go.
My lord.
My lord, I am appearing here statement.
26.
Lady, we are not pressing the matter.
My lord. Because charge sheet has been filed, we have not got the copy.
Okay. 28. Please put in your appearance.
Yes, ma'am. Doctor, item number 29, I am praying for 1 week accommodation.
$66. 29, we are praying for 1 week accommodation.
My lord, I am appearing for the petition. My lord. But in this case, my lord, case was initiated on my lord 8th of my lord,
My lord, triple AG will appear, pass over, triple AG will appear in this matter. So kindly pass over, my lord.
my lord.
Pass over. 31.
Lordship, I'm praying for not pressing the application, 31.
30 not plus.
31.
31, sorry.
Lordship, for item number 32, Lordship kindly keeps it on Thursday.
Praying for not this circuit, your lordship, next circuit. I've been instructed. Or any day on next week. Next week is fine.
Lordship, I am for the petition.
From a toll plaza, number was tracked by police. From that tracking number, phone number, so connected with that FASTag. Toll plaza, yes. From toll plaza, the FASTag number was detected, money was detected. From connection with that number was recovered, and through that number, one person was arrested. Sahid, he has not been arrested yet. He is absconding till now. From him, this name of this person has been given, but no connection, nothing has been. Charge sheet has been filed. There is no requirement of keeping him in custody more than 1 year, my lord. If my lord kindly comes to my running page number 18, my lord. Running page number 18, one of the accused person, Javed, co-accused, he has been granted bail. From his possession, the money was recovered. It is also been stated in the order sheet. Paragraph number 6, the nature of allegation levying against him appears to be serious in nature and recovered was from the custody of this petitioner. The charge sheet has been framed. Charge sheet has been framed, so there is no custody.
It was also a resident of Haryana.
No, a resident of Haryana, but he was arrested from the tracking the mobile tower. He has been arrested. That state, same state. He is also from Haryana, same state. So that's the thing. Entire gang, whether he is a gang member, that has to be established. Nothing. My lord. So if my lord kindly comes to my running page number 19 and paragraph number 6. The nature of the allegation leveled against him appears to be serious enough, and recovery was made from the custody of this petitioner. The charge sheet has been framed. Charge has yet not been framed. He was granted bail. Now, another accused, page number 22. Charge not framed because others are absconding. Till all the accused persons come before the court, the charge could not be framed. my lord. It can be framed if it is filed, case is filed. No, by this time the charge has been framed, my lord. At that time, by this time yes, sir. We are absconding. For present, the case against them has been filed. Case has been committed to the trial court, sessions court, and charge has been framed. And my lord, other accused has been filed. From this is a very unfortunate man from whose position nothing has been recovered, and no requirement of custody. At this stage, he may be granted.
Page 9 of the application.
Yes, regarding that, I would like to say that order was of 1512. 1512, there was a rejection. And after that, these two accused persons have been granted bail. One is of January and was in
Opinion of the court. The court is of the opinion, last one. Court is of the opinion, custodial trial is warranted in this case. Now, it was on December 2025. So this was the opinion of a coordinate bench.
after that.
Page 96 of the case diary. The seizure from this. Yes, Lordship.
No money. That's harbors that is planted. There's harbors or all these things. How can it be anybody?
See the materials system.
What is this? Not the money. That is, the police will at least show that they have done something. Gas cylinder, Saval, all these things.
ATM machines.
From all the accused persons. All three. All the three accused persons. My lord, my main point is the money was recovered from whom they have been granted bail. Now what remains, my lord? Why he is in custody? My lord, the main prime accused from whom the money has been recovered, they have been granted bail, my lord. No necessity, they will face the trial, my lord, on any condition. There is a much better footing, my lord, on any condition, my lord. This is a fit case for my lord to grant bail. And more than 1 year in custody.
Another thing, on 27th of March, another application was not placed.
That's a different thing. But the thing is, main thing is that two accused person from is the main thing, the matter, the money was recovered, they granted. This is a fit case, my lord.
Robbery.
যদি জমা না দেয় না তাহলে আমাকে সিএ কে
Very good. Good.
লাগবে না এটা তো করুন instructions নেই
number 42 that's item number 42
মানে item number 42 I have instructions to not press the application
There was a direction to file a reply. Reply is ready. If your lordship
Reply?
taken a record, just.
direction to file a reply when there was no direction my lord
Yes, there is a direction. Lordship-
my lord if it's a reply then I'll be prejudiced my lord if it's not a report it's a reply if it's a reply then I'll be prejudiced my lord I don't know there was no direction my lord I don't know what my learned friend is talking about
Yes, there was a earlier occasion side pay for leave to file the reply to
When?
lordship which was granted.
earlier
আছে।
কোথায় অর্ডারটা কই
No, I mean, order হবে তো।
Last occasion was rejected in January 25.
আরে না না এই মানে এই কেসে রে ভাই।
My lord, may I be given a copy as well, my lord?
Yes,
No, I'm not pressing this application upon instructions, my lord.
My lord, attempt 47 paying for short pass over, my lord.
43 pass over.
Forty-four. 44 and 45, if my lord be pleased to fix it on Monday, my lord. Monday or Tuesday, my lord. Tuesday, my lord. Yes, maybe oh, it has been my lord. It has been my lord. Then Tuesday, my lord.
Monday.
44, 45. My lord. All the courts are in that. Because we are getting this opportunity, but it's not there. So we should be habituated in this. Get soon.
46 item number.
একবারে করে দিচ্ছি
This is a case, my lord, under section grievous hurt and attempt to murder, my lord. The allegation is that, my lord, there is a petitioner and, my lord, the informant are the next door neighbors. Since long there is a civil dispute and enmity. Subsequently, my lord, on 31st, 2026, the petitioner along with other two accused persons, my lord, assaulted the victim with a sharp cutting weapon, and, my lord, subsequently he got serious injuries, my lord. The petitioner was arrested, and subsequently till date he has been in custody about 190 days, my lord. My lord, charge sheet has been submitted. My lord, in the charge sheet, my lord, there is a 14 witnesses to be examined, my lord. There is a no chance of in the near future. My lord, on the last occasion, the matter was rejected for the petitioner. At that time, my lord, the honorable court. Yes, my lord. Another accused have been granted bail. Coordinate bench was of the opinion that few more days custody is required for the present petitioner. Order of rejection, my lord, page 10. Page 10, my lord. Arjia Bibi, the mother of the petitioner, have been granted bail, and, my lord, the coordinate bench of the was of the in the same, my lord, same. Yes, my lord. I am inclined to allow bail petition. Was rejected, my lord. The court was of the opinion that few more days custody was required. Now, my lord, after 2 months, I am renewing my prayer, my lord. On any condition, my lord, charge sheet have already been submitted.
Within 2 months.
Yeah, after 2 months, my lord. Yes, my lord, this is the case of only attempt to murder. My lord, sufficient date I am in custody, my lord. Yes, my lord. Sufficient days I am in custody, my lord. 190 days, more than 190 days, my lord. At any condition, my lord. All the other accused person are on bail. Yes, my lord. Charge sheet has been submitted. Yes, my lord. Charge sheet has been annexed. My lord, page 32 of my application. Page 30. Well, last coordinate bench was of the opinion that few more days custody is required for the present petitioner, as because he is assaulted the victim.
190 days.
190, more than 190.
Injury report only.
Extremely grateful, Your Lordship. Grateful, my lord.
What is 7 item number?
Lordship, Lordship, and for the petitioner, Lordship, I'm praying for kindly keeps it on Thursday, Lordship. It is appearing for the first time.
For this matter, my lord, I am appearing for the state.
Not this one, Lordship.
Number 47.
48, Mr. Mojumdar is here.
47. Grateful.
48. I don't know, 48.
Here, my lord, I beg to appear on behalf of the petitioner, my lord. It is the matter where, my lord, bail was granted to the petitioner with modification of. Yes, my lord. Yes, my lord. Earlier, my lord, CRAN 1 was filed. My lord, kindly comes to the order of the bail first. My lord, let me show you the conditions, my lord. My lord, page number 18 of my application, my lord. This is the order of the bail wherein, my lord, 4 conditions were imposed. CRAN 3, my lord, I'll come to that. There was CRAN 1 and CRAN 2 for 2 more conditions, my lord. I'll come to that, my lord. Kindly see order number 18, page number 18 for once, my lord. CRAN 3, my lord.
Lord, I'm cutting it short. What the submission of my learned friend,
The condition was he will not enter within the jurisdiction of Darjeeling. This is one condition. The other condition was he will not participate in any political rally. So far as the second condition is concerned, that is already been withdrawn by this court on 2nd of September 2025. So far as the first condition is concerned, that he will not enter within the jurisdiction of Darjeeling, my lord, I have taken instruction from the agency, my lord. He has complied with other conditions. So far as the other instruction, my lord, condition is concerned also, my lord, the agency has no problem, my lord, if your lordship can waive the condition.
All right.
My lord.
This is the only prayer?
No, this is the only prayer, my lord.
Please come. CRAN 3 2026 has been filed, praying for relaxation of the condition within brackets small b imposed upon him by the court in CRM within bracket M 69 of 2025 on 15th May 2025. Stuff. It has been submitted by the learned advocate representing the state that the state does not have any objection if the said condition is waived at present. Stuff paragraph.
Since he has complied with
As
other conditions.
It has further been submitted that the petitioner has duly complied with the other conditions imposed in the said order. Next, in view of the aforesaid submission, comma, the condition within bracket B imposed upon the petitioner restricting him from entering into the jurisdiction of Darjeeling district stands waived. Stop. The application stands disposed of. Disposed. Item 50, is anybody there? Where is Mr. Sandeep Guharoy? He was here just now. None appears on behalf of the petitioner at the time of call. No accommodation sought. Dismissed for default.
Item number 1.
Last occasion, it has been adjourned on your prayer. Then, how many times adjournment will be allowed? Why? Why don't you try? You think senior will make a difference? You are as good as your senior. You are good enough. Then, why don't you proceed? Thursday on the prayer.
Item number 2.
Why? Where is he? Where is he?
He was engaged. Yes.
Learned Triple AG is engaged. Stop. List on 9th. Are you assisting the Triple AG? Then take instructions.
Item number 9.
9 to 18, not press. Whoever is the state, please enter your appearance. Twenty also, not press. 19 is separate. Yes, even I was wondering, 17 is not yours. 9 to 16, then 18, 20. সদরে কল করতে হবে।
Item number 17.
Yes. 17. To allow the learned advocate representing the state to come prepared, list on 9th.
Number 30.
30, my lord. I appear on behalf of the petitioner. My lord, I do not wish to press the application.
Not press.
Forty-three.
43.
43.
Dismissed as not pressed. Please record your appearance. হয়ে গেছে তো?